cases are we calling first?
If we could start with the Juan Granado case.
Sure. Mr. Granado. One. Right, so we're on the record in docket 2500625. That is people of the state of Michigan versus Juan Granado. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Milks.
Hey, good morning, Your Honor. Stephen Milks on behalf of Mr. Granado. Mr. Granado is present and seated to my right.
And sir, you are Juan Granado, is that correct? Yes, sir. Thank you. This is the time set for a preliminary examination today. Mrs. L, how are we proceeding?
Your Honor, at this time, the people are ready to move forward with the preliminary examination today. All of our witnesses are present and ready to proceed. However, it's our understanding that the defense today will be asking for an adjournment. We are not prepared to agree to that adjournment today and would be objecting to that.
All right, Mr. Milks.
Thank you, Your Honor. Your Honor, as the court knows, I do not often unilaterally ask for adjournments in these matters. That is rare. I know that people often ask for adjournments when police don't show up. In this matter, Your Honor, when I went to speak and have a meeting with Mr. Granado last night, we were unable to. I was speaking with a Dakota Miller, who's an EMT, who confirmed that my client was jumped last night. He ended up having to go to the hospital. Obviously, that needed to be attended to. That was far more important than him and I having further discussions right at that moment, Your Honor. For these reasons, in order for me to continue preparing, to have a full conversation with my client since our initial conversation, Your Honor, we are asking for an adjournment at this time. It's not going to be any disadvantage to people with them at a disadvantage. We are already prepared to waive our 21-day rule, Your Honor. And again, we are asking this in good faith, just because, again, the unforeseen events would have happened last night, Your Honor.
All right, Mrs. L, do the people have any witnesses here that they'd like to preserve the testimony of?
We do, Your Honor.
Okay, and what witnesses are those?
Today, Your Honor, we do have Mr. Bruce Grades here to provide his testimony of what happened.
All right, and Mr. Bruce Grades is one of the victims in the matter.
He is, Your Honor.
All right.
Are there officers testifying too?
There were not officers testifying today. We did not plan on having any officers testify.
So you were gonna. This is a one witness prelim.
It is, Your Honor.
Well, what I'm gonna do is I'll entertain the adjournment, the waiver of the 21-day rule. But if you have somebody here you need to preserve testimony, what we'll do is we'll preserve the testimony and then allow Mr. Milks some time for cross-examination. So the witness might have to come back, but you can preserve your testimony. I don't want to make Mr. Milks do a cross-examination if his client has medical documentation that he went to the doctor last night. Does that make sense?
I believe it would, Your Honor.
Yeah, I mean, I'm leaving it to you. I'm kind of leaving it up to you. I can have the witness testify, okay,
so
to preserve the testimony. But I don't want to make Mr. Milks cross-examine the witness if his client had gone to the hospital and can provide medical documentation that he's gone to the hospital and was treated. So Mr. Milks would be able to cross-examine the witness at a later date. If you'd prefer that the witness come get direct and crossed at the later date, I can understand.
I believe that my concern here, Your Honor, is that if I'm preserving this testimony today, the goal of that would be to not call this witness back in. And if we were calling him back in, we run into the same issue where there's a chance that date doesn't work. There's the chance the victim is unable to come in that day. There's a chance I then lose that ability to have that victim and get this bound over. That I do believe would be harming my case. Additionally, Your Honor, I did reach out to Mr. Milks earlier this week after being informed that my victim had a doctor's appointment this morning at 10:30 due to an illness and asked for a stipulation to an adjournment, which was denied at that time. And due to that, I have that victim here today and he has rescheduled that doctor's appointment. So I guess I'm at in this between a rock and a hard place where I would really like to get this completed today.
Mr. Milks.
Thank you very much, Your Honor. Your Honor, I did receive that email from opposing counsel. It wasn't a flat out denial. It was just at that time I couldn't stipulate to any sort of adjournment. And what I did put in that email, Your Honor, is the court will oftentimes grant adjournment, a good faith adjournment for something like that, for being ill or sick. I've seen the court do that plenty of times before, and I know that Mrs. L has also seen that as well, Your Honor. So even though I wouldn't have objected to it, I couldn't just stipulate it to it at that time, fully knowing, I believe Mrs. L knows as well, that the court would have granted that adjournment if that's what they really wanted, due to obvious illness, Your Honor. Which, I mean, kind of ironically is exactly what I'm asking for here on the flip side of things.
Well, I am cognizant of and this is a one witness preliminary examination is what you're requesting.
It is, Your Honor.
So I am going to deny the motion to adjourn. We're going to get the witness. We're going to direct the witness and cross-examine the witness. The witness is here, ready to testify. It is a one witness testimony concerning an assault. Mr. Milks, I'm denying the motion to adjourn, and you can go from there. All right. What I'm afraid of, and rightfully so, is that and this has happened before, we're going to lose the witness. Okay. And if the witness is here and we're all ready to go, we'll have a one witness preliminary examination as requested.
Thank you, Your Honor.
All right. Are there any other pretrial matters to be brought to the court's attention from the people in regards to sequestration?
Just a general sequestration request would be asked for. Additionally, Your Honor, due to the illness that the witness is facing today, he is having a difficult time hearing. I would ask if I could take a few steps closer to him.
Absolutely, absolutely. And Mr. Milks, feel free to cross-examine the witnesses at the space that's needed if the witness is having some difficulty hearing. I will leave it to counsel to let me know if anybody comes into court that should not be a part or should not witness another person testify who plans to be a witness in this case. With that understanding, the people may call their first witness. Mr. Milks, do you have anything to come to the court's attention before we get started in regards to sequestration?
No, thanks, sir.
All right. All right. The people may call their first witness.
Thank you, Your Honor. The people call Bruce Graves to the stand.
All right, Mr. Graves, I'm going to stand right here and please spell and state your first name and last name for the record.
Bruce, B-R-U-C-E, Grades, G-R-A-D-E-S.
Please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, go and have a seat. The recording device goes right to the court recorder. So I'm going to have you to project as best you can, which you sound good. So, and then if Mrs. L, if you want to move up closer, or Mr. Milks, in order for the witness to be able to hear you, that's fine also. All right.
I apologize. I got an ear infection.
But that's all right. That's all right, sir. All right, Mrs. L, when you're ready.
Thank you, Your Honor. Mr. Graves, thank you for being here today. I want to just start by asking, do you remember the date August 26th, 2024?
Yes, I do.
And on that day, did you have occasion to call the police?
I did call the police, yes.
And why did you call the police?
Because I had a knife wound in my neck, close to my jugular, and I had to run across the street to get away from him and hold my bike because he was going to take it. So I went and I yelled at the house, "Hey, somebody help me!" And I got on my phone and I called the police.
Thank you. And so you had that injury to your neck. I want to back up a little bit, okay?
Sure.
Where were you when that injury took place?
I was walking through the park.
Do you remember
right,
what
Morris Park? Yeah.
Thank you.
The pavilion's right up there, and he was sitting there.
And is Morris Park at 400 Morris River Drive?
Yes.
And that's in the city of Lansing?
Yes, it is.
And do you know if that's in Ingham County?
That's Ingham County.
Thank you. And that's, of course, the state of Michigan then?
Oh, yes.
Thank you. Now, while you were at that park, who did you see at that park?
Juan.
Do you know his last name?
Granado. Yes.
And do you see Juan Granado in the courtroom today?
Yes, I do.
And can you just identify him by describing something he's wearing?
a jacket with black and gray.
Thank you. Your Honor, at this time, the people had asked that the identification of Mr. Granado be placed on the record.
Mr. Moak, any objection to the witness identifying the defendant for purposes of prelim?
No, Your Honor, for purposes of prelim. Thank you.
So the witness has identified the defendant for purposes of prelim.
Thank you, Your Honor. Now, Mr. Greaves, when you saw Mr. Granado at the park, what did you do?
Well, the thing is he stole a bike from me 2 years before that and the blue
Objection, Your Honor,
$100
relevance
speaker.
at this point 2 years
And,
ago, and it's other act stuff.
All right, this sounds like other acts, but it goes towards, so I won't use it in regards to the assault. It's just in regards to what he
Okay, I
did.
yelled.
Correction.
So, hold on.
Correct, Your Honor. This would be introducing it simply to introduce the situation, just for background on the information.
But not in regards to the stealing of a bike 2 years ago or
No,
anything like,
No, Your
or
Honor.
having larcenous intent or anything along those
And he
lines.
said something.
I would just
yelled
add-
back.
I would just like to reserve my objection at this point, Your Honor, assuming there's going to be a proper foundation or authentication.
Right. I would agree that it's improper to indicate that a prior act happened in regards to larcenous intent. It does explain why he acted the way he did. That's the only way that's the only way I'm using it. I'm not using it as substantive evidence to indicate that that the defendant has more or less mens rea for larcenous intent. But it does explain why he acted. I do not expect, we're not here on a larceny. So this only explains the actions of the witness.
He came to me.
Right, all right,
Thank you.
all right. All right, with that understanding, the objection's overruled for clarification, and Ms. Azal, you may proceed.
Thank you. So you knew him from a previous interaction. When you did you approach him or did he?
No,
approach
I
you?
was walking through the park. He was sitting on a picnic table in the pavilion.
Okay, and at
And
that
he come
point,
out after me. And I was gonna get on my bike, but I waited and then he wanted to fight. So we
okay,
got in a fist fight and I knocked him down. He got up with a, like a 5-inch blade and started swinging it.
okay. So let's stop for a second there. I know this could be hard to pause in the middle of because this was a difficult situation, but let's pause there. You said you got him on the ground, but he was able to get back up.
Yeah, knocked him down and then he got up with a knife.
And now at that point, were you standing or were you on the ground?
I was standing, I was with my bike trying to get him back from me. And I had a air pump that I was trying to swat the knife away from me. He got me in the leg and then he got me in the neck and he took my bike pump.
Okay, so let's talk about that knife again. You said it was about a 5-inch blade.
Mhm.
Did you see where he pulled the knife from?
His pocket.
From his pocket? Okay. And then what did he do with the knife specifically?
He tried to jab me.
Okay, and you said where did he
He
jab?
got me first in the leg and I just got the tip of his knife, but I knocked his hand away. And then he grabbed my air pump and yanked it. And I wanted my bike. I didn't want him to take my other bike. So then he got me in the neck.
Okay,
So then I left and I tried to get across the street to get away from him.
okay. And would you recognize the injury that you sustained to your leg if you saw a picture of it?
Oh, yes.
At this time, Your Honor, may I approach the witness with what has been marked as Exhibit 1?
And Mr. Wilkes has seen People's Exhibit 1.
Yes, Your Honor.
All right, you may.
Thank you. If you could just take a look at this.
Mhm.
Thank you.
Yes.
And can you describe what that picture is?
That's where he jabbed me with a knife
Okay. And
and there's blood
is this an accurate depiction of the injury that you sustained?
falling down from, getting away from him, trying to get away from him. I didn't hurt myself that way, but it was a knife. It was
Oh,
mainly the one in my neck.
but this is where he got you in the leg?
Yeah, the first one.
Okay, thank you.
Second one was in my neck.
Thank you. At this time, Your Honor, the people would ask for Exhibit 1 to be entered into evidence.
Any objection to the people admitting People's Exhibit 1 for purposes of prelim?
No objection, Your Honor.
Without objection, People's Exhibit 1 is admitted in evidence.
Thank you.
And you
Your
may
Honor, may
pub-
we publish it to the judge?
You may.
Thank you. Can you hand that to the judge?
Pardon?
Thank you.
Oh, I'm sorry.
You're okay. I spoke a little soft there.
All right, you may proceed.
Thank you, Your Honor. that was the first injury you sustained from the knife.
Yes.
And you said the second one was where?
Pardon?
Where was the second injury?
It was in my left, right under my jawbone.
And would you recognize a picture of this injury if you saw it?
Yep, I got 3 stitches or 4 stitches in it.
Thank you. And Your Honor, at this time, the defense has seen the exhibit. May I approach the witness?
You may. Mr. Mooks, you've seen that exhibit?
I have, Your Honor. Thank you.
It was close to my jugular vein.
Objection.
Yep.
Thank you. So can you please describe this picture for the court?
Yeah, it's where I got knifed by him, right on my, right here.
And this is an accurate depiction of the injury that you got?
That's the actual picture, yes.
Thank you. At this time, Your Honor, the people would ask to admit Exhibit 2 into evidence.
Any objection to the admission of People's Exhibit 2 into evidence? Mr. Mooks?
No, no objection for prelim.
Okay, for purposes of prelim, People's Exhibit 2 is admitted into evidence.
Thank you, Your Honor. May we publish to the judge?
You may.
Thank you.
Thank you, sir.
Thank you. So after you got those injuries, how were you able to get away?
Well, I ran across the street and tried to yell to the houses there, hey, somebody call the police, and he was still up there. So I got on my phone and called them, and they had come.
Okay, and did you speak with officers at the park?
I'm
sorry, did you speak to officers at the park?
Yeah, they came, yeah. There was like probably 7 to 8 squad cars and an ambulance.
And did you receive medical treatment?
I needed medical treatment, yep. They took me to Sparrow.
Thank you. And how many stitches again did you say was on your face?
About 4.
And did you get any stitches in your leg?
No.
Okay. Thank you. No further questions at this time.
All right, Mr. Mills, cross-examination of witness, Mr. Graves.
Thank you, Your Honor. Mr. Graves, you indicated that there was a fight. The fight occurred in the pavilion. Is that right?
Not in the pavilion. It was away from it by where the water fountain was. He walked out of the pavilion at me.
Where the fight was, that is still near the pavilion. The waterfall or the water fountain is near the pavilion. Is that right?
The water fountain in the pavilion, in between, right at the water fountain but I was running away.
Okay, so
Not
it
running,
is-
but walking away.
So it is near the water fountain. The fight occurred in between the water
He's
fountain.
coming at me.
Hold on, so let me ask a question. The fight occurred between the water fountain and the pavilion. Is that right?
Yes.
Okay. And the water fountain is, if I'm where the pavilion is, the water fountain's right over there by the window. Is that right?
At the pavilion, it's more than that. It's probably like 50, 40 yards or 30,
40 yards?
40 or 30 feet. I mean, not yards,
Okay.
feet.
If I were to tell you that the room here is about 30 feet
It
wide
was farther than the window.
to the wall, see the
Maybe
outside?
close to- yeah,
So let me
with,
hold on real quick. The wall that's outside there, the building across the way. Is that fair that it's about that distance?
Yes,
Okay, so within 50 feet. Fair to say?
yeah,
Okay,
So
Now-
the record reflects around 50 feet.
pardon.
The record reflects around 50 feet.
you indicated that you knew my client from a previous encounter the two of you had. Fair to say the two of you are not friends?
No, I was avoiding him. I didn't even know he was there because I was walking up the hill and then I seen him and he said something and I said, you thief, and then he come out after me.
All right. And at this point in the day, you had been drinking, is that right?
I had a beer.
You had more than one beer, right?
1 beer.
You had more than 1 beer though.
I don't think so.
You don't think so? You don't remember?
No, I do remember. It was a 25 ounce.
All right, 25-ounce beer. And did you have liquor that day too?
Liquor?
Liquor, correct.
No,
All right. What about other controlled substances?
nothing.
All right, nothing at all?
Pardon?
You went to the hospital, correct?
Right.
And did they tell you that you tested positive for cannabis?
Oh, they may have, but yeah, I had a little bit of that in me.
Okay, so now you remember you also had some cannabis, is that right?
Yeah,
Okay. You did exchange some words with my client at that point, is that right?
that was after he yelled something. I said, "You thief."
So there was a argument between the two of you, is that fair to
Just
say?
I yelled it out and I was walking away. I wasn't even near him. He come out.
All right, so just so I understand, you were trying to run away.
I was trying to get
Okay.
away.
All right.
Yes.
Now, you indicated that when the fight did occur, you knocked my client to the ground, is that right?
Yeah, we were swinging and we were fist fighting and I knocked him down.
Okay, so you knocked him down at that point, right? And then that's when he got up, is that right?
Yeah,
Now, when he fell down, you were saying things to him, is that right?
I was what?
You were saying things to him.
Saying something?
Yes.
No, I wasn't saying, I was saying getting away from me. Get away from me. What the hell are you doing? Crazy?
Okay, so you were saying things to him.
Yeah,
Okay, all right.
trying to get away from him.
You're saying things to try to get away from him?
I was saying things as I was trying to get away from him. A couple things, not very much. I was just trying to get my safety.
Now, there were other people who were in the park that morning as well, is that right?
Yeah, there was a couple of people I think he was sitting with.
And did you know any of the people who were sitting there?
One of them was James, I can't think of his last name. And I think probably his brother, older brother, I don't know. I only know one of his brothers, Santos.
And who were you there with? Anyone?
I was by myself. I was just got off the river trail and taking a shortcut up to Moores River Drive. I didn't know he was there.
The bike pump that you have, that's something that attaches to your bike, is that right?
Pardon?
The bike pump, does that attach to your bicycle?
I had it on an elastic thing on the back and I was struggling to get it off while he was swinging a knife.
So it does attach to your bike? The pump attaches to your bike, is that right?
It was strapped on and I got it off finally. And then he ended up stealing it.
You just said that you were trying to take the pump off of your bike, but he was swinging at you, is that right?
Swinging with a knife, yep.
And why didn't you just get on your bicycle and ride away?
Pardon?
Why didn't you just get on your bicycle and ride away?
Because I didn't want him to knife me anymore. I'm trying to defend myself.
Okay.
He's right on top, right at me. Lucky to get my bike out
Objection, Your Honor, non-responsive.
in my life.
Right. Just answer the question, sir, okay?
I'm sorry.
That's all right. So the objection sustained.
Did you ever learn what your blood alcohol content was from the hospital?
No,
Your Honor, I have no further questions.
Redirect to Mrs. L.
Just very briefly, Your Honor. Mr. Graves, when you were being swung at with a knife, how were you feeling in that moment?
Frightened for my life. I didn't know. I never fought somebody with a knife.
And did you have the opportunity to stop and think about how to respond to the situation?
That's what I was grabbing my air pump to try and block his arm, and he ended up yanking it with his other arm out of my hand.
Thank you. No further questions, Your Honor.
May this witness be excused from the people?
He may.
Mr. Milks, may this witness be excused?
Yeah, yes, thank you.
All right. The witness is excused. Thank you, sir, for your appearance today. You're all set.
Oh, thank you, sir.
Just so you know, the person that you came with is in the hallway, okay?
Pardon?
The person that you came with today is in the hallway.
Okay, thank you.
All right. Any further proofs, Mrs. L?
Yes, sir.
No, Your Honor.
Any proofs today? Do the people rest, Mrs. L?
We do, Your Honor.
Any proofs today, Mr. Milks?
No, Your Honor, thank you.
All right. Motion for bind over, Mrs. L.
Thank you, Your Honor. Today, Mr. Granado is in front of you with on 3 counts. The first count is an assault with intent to commit great bodily harm. Today, Mr. Graves talked about the injuries that he did sustain from this assault. One was a cut to his leg, and that injury did not require any stitches or anything of the sort, just minor medical attention. Then he also had a cut to his face. The cut to the face on the lower part of his cheek required, I want to say he said 7 to 8 stitches, and did require medical attention. He did have to hold that wound while he tried to call out for help as well. With this being said, those injuries do show that not only was Mr. Graves attacked with a knife at that moment, but he was hit with the knife, and that knife could have caused further injuries to him. With that being said, Your Honor, we do believe that we have met the probable cause standard for the intent to commit great bodily harm. Mr. Granado is also here on a charge for carrying a concealed weapon. Today, you heard testimony that a 5-inch knife was pulled from his pocket in this situation to begin the assault on Mr. Graves. The weapon was concealed, so it was not easily seen before it was pulled out of the pocket, and it was carried by Mr. Granado. We believe that we've met the probable cause standard for that count as well. Finally, Your Honor, Mr. Granado is here on a charge of assault with a dangerous weapon. Today, you heard the testimony that a 5-inch blade was used in the assault on Mr. Graves. It is very clear that Mr. Granado did not have the intent to commit murder in this case, meeting the standard for assault with a dangerous weapon, and that the battery was committed with a knife. Based on this, Your Honor, we would ask that the case be bound over on all 3 counts to circuit court. Thank you.
Thank you. Response, Mr. Milks.
Thank you, Your Honor. Your Honor, first and foremost, I would ask that the court not bind over on either count 1 or count 3. These 2 counts are mutually exclusive based upon the people's arguments at this time. In the first one, they're talking out of one side of their mouth saying that this is great bodily harm and he had the intent to cause great bodily harm. And then on the other side of their mouth, they're saying, well, no, he didn't actually have the intent to cause great bodily harm when he had this weapon. Therefore, you should bind over on both of them. It's mutually exclusive and it's a little bit ridiculous. Additionally, Your Honor, regarding the knife at this point, I may have missed it. I didn't hear anything regarding a 5-inch blade, but I may have missed that. But the defendant or the complaining witness here also got up and indicated that he couldn't see my client. He was at least over 50 feet away for the time. He says that it was pulled out of his pocket. Whether or not that was concealed, we don't know. It doesn't indicate or it doesn't follow necessarily that it is concealed just because it is in his pocket, or whether or not that this is a box cutter, Your Honor, or if this is some other sort of tool rather than just a stabbing weapon, Your Honor. I don't think people have met necessarily the fact that this is a dangerous stabbing weapon pursuant to the instructions here, Your Honor. So for these reasons, Your Honor, I would ask that the court not bind over on either count 1 or count 3, and also then not on count 2, Your Honor. Thank you.
Thank you. Response, Mrs. L.
Thank you, Your Honor. First, to respond to the mutual exclusivity of counts 1 and 3, it is my understanding that the appellate court here in Michigan has stated that both charges can be brought against the defendant. One requires an intent to commit bodily harm. The other does not. The other does require that a dangerous weapon is used, meaning that both of these counts do require that two separate elements be met. Additionally, Your Honor, the argument that I made in my original argument was that there was no intent to murder. I do believe that the testimony that was given today did show an intent for great bodily harm, but nothing past that. Additionally, for the concealed carry count of count 2, we do believe that is enough that the knife was concealed in his pocket. The standard or definition of a concealed weapon in this count under the jury instruction 11.1 is that it was concealed so that it could not be easily seen. A 5-inch blade in the pocket of a person would not be very easy to see unless that pocket was very short and it was sticking out of the top. That is not what happened in this case. The knife was pulled from the pocket and was not able to be seen from the victim beforehand. With that, Your Honor, we do ask that all 3 counts be bound over. Thank you.
All right. The standard for preliminary examination is probable cause being the second lowest standard, reasonable suspicion being lower standard. I find by probable cause evidence that this occurred. The location and venue are 400 Moores Drive in the city of Lansing, Michigan, 48910, that it happened on August 26, 2024, at that date and time, and that identification was made by Bruce Philip Grades as to made the in-court identification of the defendant, Juan Jose Granado. So location, venue, ID, and date are made. As to the elements of the crime, I find there's probable cause evidence to bind over on count 1, assault with intent to do great bodily harm, less than strangulation. Mr. Granado indicated that he was walking near the pavilion with his bike, that the defendant approached him, ran at him, and then there's People's Exhibit 2. So based on the testimony of Bruce Philip Grades and the Plaintiff's Exhibit 2, he indicated that a knife was pulled. We'll get into that later. And 3 stitches were made. The place of the knife in the photograph of People's Exhibit 2 is from the middle of the cheek down to the beginning of the neck. And then the witness indicated there were three stitches that went along with that. I find the placement of the knife strike and the fact that he's using a knife in a knife strike is probable cause evidence that the defendant did make assault upon Bruce Philip Graves with the intent to do great bodily harm for the strike to the head with a knife. We'll get into the knife later, but the victim indicated, and I went back and looked because I might have missed it also. I'm along with counsel that Mr. Granado called it would start out as a fist fight and then turned into a knife fight with the defendant carrying a 5-inch blade, and he got me in the leg and the neck. That's how. And then there was some clarification as to what got me meant. Okay, with that understanding, count 1 is bound over as charged. Count 2 similarly is the carrying concealed weapon. This was concealed on his person. It was brought out. The victim called it a 5-inch blade. There's some question as to when he saw it, depending on when he was at the pavilion versus the water fountain. But there's no doubt it was up close and personal as he was hit in the neck and the leg with it. And so I find there's probable cause evidence for location, offense, venue, ID, and date that this occurred on August 26, 2024 at 400 Moores River Drive in the city of Lansing. In count 2, I'll bind over his charge. The defendant did carry a dangerous weapon, to wit, a knife concealed on his person. And in count 3, which is I'm treating as a different count. Okay, that was a felonious assault. That's plaintiff's exhibit 1, and that was the attempt to stab him in the leg or to get him in the leg, depending on what vernacular you use. And that is a photo of plaintiff's exhibit 1 of the knife, of a small knife wound to the leg. That was obviously a part of this situation. So that occurred on August 26, 2024 at 400 Moores Drive in the city of Lansing. that the victim was offensively touched Bruce Phillips Graves with a dangerous weapon. There's a small mark, and he indicated that he did get me there, but there is a small mark that led to, and it was the testimony of the victim that he received that wound with a knife. The mens rea is that he may have wanted to greater damage. We don't know that. We do know that he attacked him with a knife and that he hit him with a knife, and therefore I will bind over on that count also. And then the habitual fourth offender notice will follow. So this case is bound over as charged on the 3 counts, and the offender notice will follow. I will indicate that the examination was held on today's date, which is March 28th, 2025. Probable cause exists to believe that the counts 1 through 3 occurred, and I will bind over as charged. So, Mr. Granado, your time in district court is done. You're off to circuit court. Well, you'll get your next notice to appear in circuit court from Mr. Milks, your attorney. Anything else before I sign the bind over documentation concerning the examination, Mrs. L?
Not for the people.
Mr. Milks?
No, nothing expensive.
All right, Mr. Granado, I will indicate for the record that I don't know who was arguing for you at bond, Mr. Granado, but you received a 10,000 PR bond from the magistrate. You wouldn't receive that 10,000 PR bond from me. All right. You did yourself quite a service by coming to court today, because I can say that you are here, and that's part of what we determined. You have 3 prior offenses and 2 assaultive crimes, and you would not receive a 10,000 PR bond from me. All right, sir. All right. I'm going to sign the document accordingly. This March 27th. And that's all for the record. Thank you for your appearance today. And then, Mrs. L, I'm going to return your exhibits to you.
Thank you.
Mr. Milks. I know Mr. Etheridge is here on the forensic review.
Yes.
Is Mr. Harris, is he being brought today? Do we need to go get him, or?
That's him right there.
All right, all right.
We'll be ready to handle the Van Atten exams when the court is.
All right. With that plans on being and that's running.
Yeah, I think so.
So let's see if what we can move before we start that.
I will say it should be one of my quicker.
Okay.
Hey, I know that's
Everybody
a low bar.
starts snickering at
I
that.
know that's a low bar.
Honestly, I saw your email
But
the other day and I didn't.
they will be.
You're got. Mr. Harris, we'll call your case. We're on the record in docket 2402117. That is People of the State of Michigan versus Joseph Harris. Will the parties please introduce themselves for the record? Mrs. Zell.
Gabrielle Zell, Assistant Prosecutor for the People.
Mr. Etheridge.
Morning, Your Honor. Attorney Derek Esposito, Public Defender on behalf of Mr. Harris. Mr. Harris is appearing by video from the Ingham County Jail.
And sir, you are Joseph Harris, is that correct? Yes, sir.
Yes.
Okay, thank you. This is a time set for, I have it set for both a forensic review and a contempt hearing. Ms. Zell, how are we proceeding?
Your Honor, if I could defer to Mr. Etheridge.
Mr. Etheridge.
Your Honor, regarding the forensic review, and this is part of the bond violation as well, I guess, or the contempt hearing. I will give an explanation of why he missed and then address the bond issue and then address the forensic issue. Your Honor, we got a letter and from the Center for Forensics advising us of the date and time, and it's our responsibility as the public defender and me as his attorney to make sure he received that date. My social worker, and investigator had contact and good contact with him. But for some reason, when this issue came up, we called him several times. We left messages about the date and time, asked him to call us back to discuss it so we can give him additional information. He was to go to Ypsilanti for the assessment. For whatever reason, he did not receive those messages. We also left them for the daughter. She claims that she didn't receive the messages either. We did email him a copy of the paperwork we received, but for some reason, he did not get it until the day of. In fact, it was a couple hours after the appointment was supposed to start that he actually received the email, and it was too late for him to go to that appointment. He understands the necessity and requirements of the court to get the assessment done. I've drafted, or my paralegals drafted, stipulation and order asking the court to order it to be reset. And we're asking that if the court is inclined when I address bond to reinstate his bond, that he be allowed to actually do it by Zoom, and we will accommodate him. My social worker will work with him to get him into our office to do the evaluation by video through Zoom. And that's part of the stipulated order if the court is inclined to sign it.
All right.
Regarding bond, yesterday, Your Honor, I did call the bondsman. He has, as the court knows, a very high bond of 100,000 cash. His daughter and son-in-law are actually the signers of that bond. I talked to Kyle at Tops Bonds, and he advised that after talking to me, after talking to the daughter agreed to stay on the bond as the signee and the person that is responsible. To have the bond reinstated, or he'll stay on the bond if the court would reinstate the bond. He also advised me when he talked to the daughter would take appropriate action to get the tether placed back onto Mr. Harris. So we're asking the court to maybe take the bond violation and to not take any action on it, maybe take it under advisement and give him another opportunity to try to get the assessment done. To order the assessment, and if possible, have the Center for Forensics to conduct the assessment by video, and asking the court to reinstate his bond. Thank you.
Thank you. Mrs. Zell.
Your Honor, I want to start by saying, obviously, we stipulate to the rescheduling of the examination of the review, I'm sorry, for Mr. Harris. However, Your Honor, when it comes to the bond, due to the failure to appear at the last forensic meeting, we would be concerned that he wouldn't come again. If the court were inclined to reinstate that bond, we would potentially ask that it be contingent on that forensic meeting being done first, and getting that review done first before that bond is reinstated. Thank you.
All right, the court will order that there's a stipulation to reschedule the interview. I will grant the motion to reschedule the interview. I'm not changing bond. The defendant is remanded for forensic review. until the interview process is done. Then I'll entertain a motion to reduce bond at the time, but I want him interviewed because we don't know if he's going to show up, and we don't know. And I would indicate that this is a life offense. It's a count one life offense. So now we're really treating it with kid gloves, so to speak. So I will stipulate to reschedule the interview. I know the interview will take place because the defendant is remanded until the interview takes place, and then I will entertain a motion for bond at that time after the interview takes place. And I will sign an order accordingly. So I can sign a stipulation for the order, but I won't sign a reduction in bond.
Tanner, if I could approach with the order for.
Absolutely. All right, thank you. So I have in my possession a stipulation order to reschedule the forensic assessment that is signed. So this is for the defendants, parties stipulate and agree defendants forensic assessment be rescheduled. And then I'll strike section 7 because I don't know if it's going to be via Zoom or not. They have to come and see him, and so they'll have to interview him. They can. I'm assuming they'll do it via Zoom.
They'll do it by video if he's in
But
jail.
okay, but it won't be done at your office.
No, if
Yeah.
he's in jail, it'll be done, accommodated by the jail.
All right.
But they will do it by video.
I will strike the Ingham County Office of the Public Defender with both parties agreement, and then with the understanding that I've remanded him. So it will not be at the Office of the Public Defender. It could be via Zoom. Is that a fair statement?
Yes, Your Honor.
All right. Okay. All right. I will strike that Ingham County, and I will at the center. Okay. I will sign it accordingly. And then we will wait for after the interview, the report to come, and then I'll entertain a motion for reduction of bond after the interview is done, since we've got a problem with making sure that the interview is done and the report's done. Okay. Anything else for the record in 2402117, Mrs. L?
No, Your Honor.
Mr. Etheridge.
Your Honor, regarding the rescheduling order, if the court could have the staff email me a copy, I'll get it to forensics today.
All right. Should we set this for some type of control date just in case?
It would probably be.
It'd probably be sent for the interview and the report. We're waiting for both, but to set it just so we keep track of it. So let's go ahead and set a control date. I would think 60 days out, if not 90 days out.
That sounds fair, Your Honor.
Yeah.
June 13th at 8:30.
June 13th. At 8:30 for control date. We'll make sure that's in the computer because I don't know if this is gonna be able to be legible. So June 13th at 8:30 for control date, just to keep track of the file. That's all for the record in 2402117. Thank you, everybody, for your appearance.
Thank you, Your Honor.
Mr. Etheridge,
Yes, ma'am.
I'm gonna go ahead and send this stipend order. I have an email up and CC all parties.
So Mr. Harris, Mr. Etheridge will be out to see you. You're all set today.
Thank you, Mr. Harris.
I don't know what your schedule's like today. Were you able to go and talk to?
Yeah, I don't know if he's here yet, but yeah.
I don't know if it's. My victim's on board. She's gonna be here.
So
They usually bring the defendants, you can schedule it in the afternoon, in the mornings too. They usually. sit
Okay, so
down
he's
all
probably
day.
here.
Yeah.
Yeah, I'll try to
Usually
start
make
now.
two
And if you can-
trips.
That helps.
Yeah.
Something.
I have Mr. Hudson, Mr. Moshi, Van Atten's a prelim, and then Mr. Johnson, you're on my end, is that correct?
That's correct, Your Honor.
Okay, could you scan this to me real quick so I can send this?
Mrs. L, how are we proceeding today?
Your Honor, if we could go ahead and call the Mark Hudson case.
Mr. Hudson, and that's Mr. Palmer.
That's me, Judge.
All right, so we're on the record in docket 25-00609. That is People of the State of Michigan versus Mark Hudson. Will the parties please introduce themselves for the record? Mrs. L.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Hudson, who's standing to my right.
And sir, you are Mark Anthony Hudson, is that correct? All right, thank you. This is time set for preliminary examination today. Mrs. L, how we proceeding?
Your Honor, today we are asking for an adjournment. The witnesses on the people's case were not properly subpoenaed for today's date, so we do not have any lay witnesses that testimony would need to be taken for. The officer on the case is here and we would be able to begin and continue. However, after discussing with defense counsel, we decided it might be best to ask for an adjournment.
All right, Mr. Palmer.
Thank you, Your Honor. I certainly that is my understanding as well. Mrs. L communicated that to me. I think it makes the most sense, or my preference is always to take all the witnesses on the same date rather than start. And so I do think we need a new date. I don't have any reason to believe that Mrs. L, when she says that the subpoenas, didn't go out, that happened. Those kinds of things happen. My only, I guess, concern, and there's nothing that any of us can do about it, but my concern, at least with regards to what my client communicates to me, is that the two complaining witnesses in this matter have been harassing him over, I guess, text or social media of some sort, talking about how they're going to appear for court today. So it does sound like they didn't get their subpoena. Maybe they were aware of the court date anyway. Nonetheless, we'll get a new date. We'll see what happens.
All right, Mr. Hudson, there is a no contact order with some of the witnesses. So if they're contacting you, make sure you contact Mr. Palmer, contact the Lansing Police Department to make sure, because you're the one who's going to suffer because of their contact. The only thing that trumps a no contact order is another no contact order or something from the court. So just be wary, okay? That's set for your own protection, mostly if they're contacting you, okay? I will grant the adjournment for the stipulation. This is adjourned for good cause, so Mr. Hudson does not have to waive any rights in the matter since he's ready to go for preliminary examination, but pursuant to stipulation, I will grant for good cause and reschedule the preliminary examination. Now, here's the problem. We're probably going to have to reschedule it after April 21st. Okay, so if with that understanding, that's not, but I'll get a date after 21st.
May 1st at 1:30.
How much before that do we have in pre for PCC days?
The 25th, I know we will have 10, plus we already have 5 extra scheduled.
Okay, so that's
And the PCC day, I do have an exam, 5 sentencings, and 2 reviews, and a full afternoon of civil.
all right. So is that what's the PCC date?
April 24th.
All right. So we do have some other things scheduled. We can set it for May 1st, or we can use the afternoon of April 24th, and then you'd be in the middle of other, but that's a sooner date, or we can take the May 1st date.
So, I'm sorry, if we could take the May 1st date, I would prefer that. I have a bunch of stuff with Judge Jamo, who runs his circuit court docket
Right.
on Thursday afternoons. I have a ton of stuff on the 24th. So
Mrs. L.
The May 1st date works for us.
All right. That probably works best for us. Well, we could find a better date, but if that's a better date for schedules, let's set it for May 1st at
1:30.
1:30.
Got it.
So we've adjourned this for good cause to May 1st at 1:30. On file 25-00609. Anything else for the record, Mrs. L?
Not for the people.
Mr. Palmer?
No, Your Honor, thank you.
All right, Mr. Hudson, we'll see you on May 1st at 1:30.
Okay. All right, so they'll give you a new notice. And then Yep. I'll be in touch.
And do you want to call Mayan or Moshi before Van Atten?
Moshi, and then I believe we'll also be calling Maya.
All right.
for Van Atten.
So Mr. Palmer, you've got Moshi and
I
then,
do, Judge.
and then we'll go on to Mayan. All right, so we're on the record in docket 25-00727. That's People of the State of Michigan versus Louis Moshi. I think I'm saying that right, but I don't know. Would the parties please introduce themselves for the record? Mrs. L.
Gabrielle Lizelle, Assistant Prosecutor for the People.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Moshi, who is not here to be present today.
All right. This was scheduled for 8:30. It is now 10:21. And I don't see a Mr. Moshi in the Zoom courtroom or physical courtroom. I believe Megan's been out in the hallway, but based on the representations of the council, Mr. Moshi has failed to appear for the preliminary examination today. Ms. Zell, how are we proceeding today? How would you like to proceed?
Your Honor, this is Mr. Moshi's first failure to appear, and it's not a violent crime. We would like to ask for a bench warrant, but potentially with a 48-hour hold to give Mr. Palmer the opportunity to try to get in touch with Mr. Moshi.
All right, and Ms. Slaviak, you had the opportunity to call the hallway, and Mr. Moshi is not there.
It's just Mr. Johnson and his client.
Okay, Mr. Palmer, any response to the request for bench warrant bond forfeiture with a 48-hour hold?
Judge, I certainly understand the request and I appreciate the prosecutor being willing to grant a 48-hour hold if the court agrees. I will say that I did not, the contact information I received from Mr. Moshi at the time from the arraignment was not actually good for him. It turned out to be not a valid phone number, not a valid email. He did appear via Zoom for the PCC. I was able to talk to him at that time. He provided me a new phone number. That phone number is disconnected. So I don't have any good contact information. I think I have a number that I think is maybe his sister. I will continue to try to track him down over the next 48 hours and I will do my best. I just don't know whether I'll be able to.
All right. This is an inchoate crime of attempted home invasion. So I don't think it falls under the assault of crime purview. So I'll grant the bench warrant and bond forfeiture. We'll place it with a 48-hour hold. To give the council the opportunity to get Mr. Moshi in order to at least to reset it and to let us know that it's reset. And we'll reset it. Otherwise, he will have a warrant out for him after 48 hours. Anything else for the record in 25-00727, Mrs. L?
Not for the people.
Mr. Palmer.
No, Your Honor.
All right, you should be all set. Thank you.
Thank you.
And then for the Egwil Mayan case, Mr. Johnson just stepped out into the hall to speak with his client about the rights for.
Then Mr. Milks is here on Van Atten.
Yes.
All right. We can. 0759. That is People of the State of Michigan versus Aguila Mayan. Or Mayan, will the parties please introduce themselves for the record? Mrs. Zell.
Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Johnson.
Good morning, Mayor. Please, Honorable Court, Kareem Johnson, appearing on behalf of Mrs. Mayan,
Yes,
who's standing in my immediate right.
All right, ma'am, you are Aguil Mayan, is that correct?
Aguila Mayan.
Aguil Mayan, thank you. This is the time set for a preliminary examination today. Mrs. Zell, how are we proceeding?
Your Honor, at this time, the people have extended a plea offer to the defense. The plea would be to the count 3 of MDOP less than $200, which is a misdemeanor under 75377A1D and is a 93-day misdemeanor, a $500 fine. Upon successful plea and sentencing, we would be dismissing the remainder of the counts, which would be count 1 R&O and count 2 assault and battery.
All right, so if I understand the plea agreement correctly, the offer is a plea to count 3 and dismiss counts 1 and 2. Is that correct?
Correct, Your Honor. There's also an agreement to pay restitution to be determined by probation services.
Probation. I'll re-indicate that for the record, Mr. Johnson, is a plea to count 3 of the 93-day set under 750.377A1D, 93 days under $500, with a plea to count 3. Counts 1 and 2 are to be dismissed upon successful plea and sentencing on count 3, and restitution is to be determined by probation. Is that a fair statement?
It is, Your
Is that your understanding, Mr. Johnson?
Yes, Your Honor.
Right. May I inquire of your clients of their advice of misdemeanor rights, and you have an advice of.
May I approach, Your Honor?
Yes, you may. Thank you, Mr. Johnson. All right, so Ms. Mayan, you signed the bottom of this, is that correct? This describes all of the advice of rights concerning the 12 rights you have in this file. I'll indicate the 3 major rights in this. You understand you have the right to be tried by a jury, to be presumed innocent until proven guilty, and you have the right to testify at any trial or choose not to testify, and your silence can be used against you. Do you understand that, ma'am? All right. I will accept the advice of rights in the file. I'll place it in the file, dated and signed by the defendant and Ms. Mayan. And if you please accept it, you'll give up the claim the plea was the result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be pleading guilty, since you won't be having a trial. You'll be pleading guilty to the misdemeanor MDOP charge. Is it your wish today to plead guilty to the misdemeanor MDOP charge? Right. I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring your attention, ma'am, back to March 12th, 2025 at 1014 Lake Lansing Road in the city of Lansing, Ingham County. Were you present on Lake Lansing Road at 1014 Lake Lansing Road in city of Lansing, Ingham County on March 12th, 2025? And at that time, you were accused of injuring a door frame that belonged to Theodore Perez Gomez. Why don't you tell me about that, ma'am?
Well, at that moment, I was, we had an encounter before, and he pushed me out of the house while I was trying to help my sister. And I was a little physical with the door.
Okay, so you did damage to the door frame, is that correct, ma'am? All right, and at the time you did damage to the door, it was done because you were mad. It wasn't done by accident, it was done because you meant to do damage to the door frame. Is that correct?
No, I didn't mean to do it. I didn't mean to, but I meant to help my sister.
All right.
Why do I say that?
I have. So in helping your sister, did you do damage to
I did.
and you meant to do damage to the door frame?
Yes.
Okay. All right. So I find a factual basis for willfully injuring a door frame belonging to Theodore Gomez while you were attempting to help your sister.
Yes.
All right. All right. Any objection to the factual basis for malicious destruction of property, Mrs. Howell?
No, Your Honor.
All right. Mr. Johnson.
Just one question. Ma'am, you didn't live at that residence, correct?
No.
And you were put out of that residence.
Yes,
You wanted to help your sister, but your sister was in that residence,
yeah, she was
And-
screaming my name too.
but there was nothing preventing your sister from leaving.
No,
Okay. It was, your sister was in a domestic situation with her living partner.
yes, and I apologize, to her too.
All right. All right. Anything towards the factual basis after your questioning, Mr. Johnson?
No, Your Honor, thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made in regards to the malicious destruction of property under $200. And we'll refer this to probation, mostly for the restitution, to see what the restitution is. So the complaining witness will be contacted in regards to probation. So probation's on the 5th floor. If you go down and all the way to the right, Mr. Johnson can take you there. They'll either see you now or they'll set up an appointment. Most of the time they set up an appointment because they don't know you're coming. And then we'll see what options are available to us in sentencing, okay? All right, and make sure that you're candid with what happened during the event with them, all right, ma'am? Okay. Anything else? What's the sentencing date?
With June 5th at 8:30 work for Mr. Johnson's trial.
Mr. Johnson, does June 5th, 8:30 work for your schedule?
Yeah.
All right. We'll set for June 5th at 8:30. Anything else for the record in 25-00759, Mrs. L?
For the people.
Mr. Johnson?
Not for the fifth, Your Honor.
All right, Ms. Mayan, I will see you on that June 5th date. Good luck to you, ma'am, okay?
Everybody have a good weekend.
You too, Mr. Johnson.
Just a moment, I'll have notices, everybody.
Oh, yeah.
I wasn't expecting it to go that easy.
We can bring up Mr. Van Etten.
Yeah, we'll bring up Mr. Van Atten and then just let me know when we're ready. Did we start Mr. Van Atten already? No,
That's
Mr.
Brooks.
Johnson,
That's this
Yes,
afternoon.
ma'am.
that's this
Are you
afternoon.
retained or conflict?
A conflict.
Thank you, sir.
All right. That Brooks is the one that we've already done.
Which I spent time going through the transcript, so I have exact page numbers to support each of the counts. So we should be able to streamline it pretty easily.
That was my fear, is Mr. Freeman's gonna need to be walked through. Yep. Okay.
Oh, I've taken steps to
All right.
alleviate that.
All right.
Just let me know when you're ready.
Absolutely, Your Honor.
Megan, you can go get Mr. Van Atten.
Okay, Judge.
She'll just email me about it. I'm like, you guys are patient.
Yeah. Like,
I'm not lending
it's
you
not
mine
even
though,
noon
because what
yet.
you did with my USB.
Earlier.
That's fair. I
So-
did
Cindy's-
recklessly and immediately destroy it.
Cindy.
That was a low point for Adam, the office tech support. That
Are we running both exams?
yeah,
Okay, I'm gonna go to the back.
go for it.
Probably.
But we're writing them separately.
Yes, separately, we're gonna take them in chronological order.
Thank you.
You let Officer McLean leave, right?
I did. I even signed for him.
so we're back on the record in docket 25-00714. And Mr. Pfeiffer, you may call your next witness.
Thank you. People call Agent Sumter.
Your Honor, after speaking with Mr. Sumter, speaking with Mr. Pfeiffer, Your Honor, I think at this point, people have the evidence. They will eventually have the evidence. This is what I conveyed to my client. We are willing to stipulate the fact that he has been previously convicted of a felony.
All right, and then and is that so that this then that'd be that would be the stipulation to
Yes.
the being a prohibited person, and then
Yes.
the rest of it is whether he
And-
was in possession of a firearm.
Just for CYA brass tacks, stipulation for both files, right?
Yeah, that's fine. The fact that he's been
All right,
previously
I
convicted.
don't want to have to call him back on the second one.
Right.
all right. So on file 25-00714, the officers, there's a stipulation that that the individual was a prohibited person, so you cannot carry a fire or cannot handle or carry or be in possession of a firearm. And on file 25-00714 and 25-00701. Is that a fair statement, Mr. Pfeiffer?
It is, Your Honor.
Mr. Milks?
It is, Your Honor, just for my client's edification, we're not stipulating to the fact that you did or did not have a handgun or anything like that, just the fact that it was a prior conviction.
Right, that that he was on probation for a prior conviction.
I don't think he was on probation.
Okay,
He wasn't on probation yet. He had been found, he had pled guilty in October, then warrant status happened, and then he was sentenced like a week.
all
ago.
right,
But it
perfect.
still counts for the conviction for the
All right.
statute.
For the statute purposes.
Yep.
All right, with that understanding, Mr. Sumter, your appearance is not needed today, so thank you for your appearance.
Thank you for the long trip up there.
Not a problem, yes.
And Mr. Pfeiffer, you may proceed with your next witness.
Thank you. People are going to call Officer Vanderwood.
So it's Officer
Zachariah.
Zachariah Vanderwerf. All right, Officer Vanderwerf, you can come up here. Please stand right in front of me and state your first name and your last name and spell them both for the court reporter.
Yes, my first name is Zachariah. That's Zachariah. Last name Vanderwerf. That's Vanderwerf.
All right. Please raise your right hand, sir. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, you can have a seat. The microphone, as you know, is for recording purposes, so please project as best you can. And Mr. Pfeiffer, when you're ready.
Good morning, Mr. Vanderwerf.
Good morning.
Where are you currently employed?
With the City of Lansing Police Department.
And what is your role there?
Road patrol officer,
How long you been an officer with the LPD?
8 years.
Now, in the course of your duties as a Lansing police officer, have you previously had contact with a DeAnthony Van Atten?
Yes.
And what was the nature of those contacts?
I've had multiple contacts with him in the past. Back probably in 2020, if I had to guess, was probably the first time I was having contacts when he used to live at 912 Johnson. And then,
Sorry, no, never mind. Never mind.
and then also I've arrested him previously before for a flee and elude. And then,
And that, Your Honor, I would be objecting to the fact that we're bringing in other acts at this
All
point.
right, so this is not being used for substantive purposes concerning the other acts. It's being indicated, an indication as to why there's specifically in clarifying why there's been other contacts and why he knows DeAnthony Van Atten. So that understanding, the objection is overruled. This is not used for substantive purposes or character purposes, only for some of the identification measures that have been used in order to be used for the past.
I will say the testimony of this officer is solely for identification, not for any type of propensity or other acts or anything along those lines. So, officer, could you please continue where you left off? You said there was a fleeing elude that you had arrested him for.
yeah, and then also a resisting and obstructing charge.
Now, did that case actually end up in a plea?
I believe so. You'd have to ask whoever was assigned to that, but I believe there was a plea for that, yes.
Now, do you see Mr. Van Atten here today?
Yes, I do.
And can you point out where he's located? Maybe something he's wearing that people around him are.
Yeah, he's right over there sitting next to the defense attorney. He's wearing Hingham County jumpsuit, looks like.
If the record of collective is identified the defendant as D'Anthony Van Atten.
Okay, the record reflect that for purposes of prelim, the witness has identified the defendant. Mr. Milks.
Yes, Your Honor, I'm objecting at this point. So far, and I don't think there will be evidence of the fact that Mr. Vanderwerf, one, was actually at the scene, two, actually spoke with the complaining witness in this matter, three, witnessed any sort of incident actually occurring at this point. He lacks personal knowledge. And it would be unduly suggestive at this point, Your Honor, for him to just identify my client. Essentially, all he is saying, Your Honor, is that yes, he has seen my client in the past, but there's been no indication that my client is identified as the suspect who was actually at the scene that day, Your Honor. And this officer cannot actually put my client at the scene that day. No photo lineups. To my understanding so far, the evidence has been, and there's been no photo lineups or anything else identifying my client. Essentially, all he's doing is just telling the court my client's name.
Correct. That's my understanding is this is for identification purposes only. Is that correct?
It is, Your Honor. I believe for preliminary examination that there's a sufficient foundation for an identification for bind over with the collaboration of testimony and stipulations that have taken place.
Right, with the understanding that everything was said was true as to the clarification for the objection. The witnesses identified the defendant as being D'Anthony Thomas Scott Van Atten, the same person visually that he knows of as D'Anthony Thomas Scott Van Atten. And so with that understanding, the witnesses identified the defendant. So you may proceed, Mr. Pfeiffer.
I have no further questions.
All right. Mr. Milks, do you have any questions or cross-examination of Officer Vanderwerf?
I guess just to create the clean record. Sir, were you at the scene of this incident?
No.
And did you take testimony or hear anything from the complaining witness in this matter?
No.
So you heard all of this, you heard my client's name through other people, is that fair to say?
I was just subpoenaed to come here from the courts.
Okay, but you read this in a police report, I assume?
I did not really read this in any police report.
Okay, so you have no clue about what this case is about, really?
Not really.
Okay, that's fair. So you're just here to say, look, this is Mr. Van Atten. Is that pretty much it?
Yes.
All right. Thank you, Your Honor.
All right. Any redirect of the witness of Mr. Pfeiffer?
None, Your Honor.
May this witness be excused
From this file.
from this file.
He
So-
will be called back shortly on the next one.
So you are excused, Mr. Milks, may the witness be excused from this file on 25-00714.
I mean, absolutely, Your Honor. Do we need to call him back?
For clarification purposes, maybe not, but I'll leave it to counsel.
Hey,
But it's 5 minutes of identification.
I've tried taking testimony in 2 cases at once. I got yelled at a lot, and now Wendy lost her voice as a result.
Right, so we have a second file here. You are excused on this file, okay, sir?
Yes, sir.
Thank you for your presence.
And Your Honor, I would say, I'm still making my objections just regarding the identification here. However, that being said, I'd be fine stipulating to this testimony being used here, the court taking judicial notice of the identification being made, just so the officer can leave. Again, I'm still preserving my objection, but
Stipulating that the testimony would be the same in this file as the other.
and there's no point.
All right.
Does that make sense,
I
sir?
think that's fair.
All right, so there's a stipulation that the testimony of Officer Vanderwerf in 25-00714 is also the same, would be the same identification testimony in 25-00701. Is that a fair statement, Mr. Pfeiffer?
Yes, Your Honor.
Mr. Mills?
That is, Your Honor, yes.
All right, with that understanding, you're excused on both files. You can leave today.
All right, thank you,
Thank
sir.
you. And that should clarify that for a difference, because we'll call 00701 with its own testimony.
Yes, and the same connecting testimony
Correct.
to be in that file.
All right, anything else on the record or any other witnesses? So we have Officer Vanderwerf. Any other witnesses today on file 25-00714, Mr. Pfeiffer?
No, Your Honor, none on that file. There's 2 files.
All right, Mr. Milks, so do the people rest on 25-00714?
Yes, Your Honor.
Mr. Milks, is there any testimony today on this file from the defense?
Yes, Your Honor. The people would like to call Catherine McGovern. My understanding is that she's already been subpoenaed. We know where she is, and I believe that the people are It's very easy for them to pick her up. So we would just ask for some assistance in that, Your Honor.
All right, so did you subpoena her for today?
The people have, Your Honor, that's what we were relying on here, Your Honor.
Okay, Mr. Pfeiffer.
She's unavailable.
No,
She is literally having seizures and had to take her child to the hospital.
All right. So the prosecutors is responsible for setting the proofs. They did subpoena the victim. The victim is under a medical indication or some type of medical indication. She's not here today. The people have proceeded under the court rule of 276827C. Mr. Milks, you're depending on the people's subpoena. You did not subpoena herself. Is that correct?
Sir, one, yes, that is correct. Two, we're more than willing to do an adjournment understanding. My understanding, I believe her children have seizures.
No,
But either way, I understand. I could be wrong.
Yeah.
Nevertheless, yeah, we're more than willing to adjourn this, Your Honor, so we can bring her in. Again, yes, we can rely on the people's subpoenas, Your Honor. We'd have to do the same thing here, probably ask the people to assist us in subpoenaing her because the people don't often like to give out those addresses. So, Your Honor, we would be asking for adjournment in this matter. We'd be able to subpoena Ms. Governor.
Response, Mr. Pfeiffer.
I don't think it's necessary. And I think at that point, it's overly cumulative to quote an argument the defense likes to use a lot in these situations.
All right. I'm going to indicate that the people have closed their case. This case is going to the defense. The defense has not subpoenaed the victim in the matter, and she's not answered the prosecutor's subpoena, and they are not asking for any type of show cause in regards to her failure to appear. So I will not grant the adjournment in the matter. Anything else, Mr. Milks?
But then just to ask if the court would consider just an adjournment so that we could subpoena her, again, understanding that we anticipate that she would be here, Your Honor.
All right. Mr. Pfeiffer response to the second request for adjournment.
Same response as before, Your Honor.
I'm based on the proofs provided by the people and the resting of their case, I'll deny the adjournment in this matter, and I look for a motion for bind over from the people.
Your Honor, I believe there is sufficient factual basis to bind over on the felony count, that being count one, attempted assault with intent to do great bodily harm, less than murder, or by strangulation. Frankly, it could fall under both of them. She told the officer that he had her in a chokehold and was strangling her, but that he did not actually succeed in cutting off her airway or her consciousness, which is why they fall under attempt. But more than that, it could also fall under attempt GBH, as he was telling her that he was going to beat her ass. Now, the fact that he was not successful in that is something we should all be grateful for. And that's why it's charged as an attempt and not the full GBH/strangulation. So I believe that there is sufficient factual basis to bind over for count one. Then for count two, possession by a prohibited person. I know the defense questioned about, well, it could be a BB gun, it could be this, could be that. However, the facts that we have in evidence is the victim told the officer he had a gun with a clip. And by stipulation, he is qualifying under the statute as a prohibited person at the time of this offense. So I believe there's sufficient factual basis to bind over for count two, and then the accompanying count three felony firearm. I'd ask you bind over as charged.
Response, Mr. Milks.
Thank you, Your Honor. The people do have the burden in this matter, Your Honor. I know the people are trying to say that it was a gun here, but as it is their burden, Your Honor, they haven't been able to disclose whether or not this was actually a firearm. Even the officer, when asked, was this a firearm that was, would expel a bullet by means of explosion? I don't know. So they don't have the element of a gun here. I know the people have tried to say otherwise, but that just doesn't work. Your Honor, we would also consider the fact that the specific testimony here from the officer was that she did not lose the ability to breathe or lose consciousness. That is denying the essential element of strangulation. There's no evidence, absolutely zero, nothing on record indicating that her ability to breathe normally was inhibited. The court cannot bind over on that regarding strangulation, Your Honor. I ask that the court dismiss regarding the any charges regarding the firearms in this matter, Your Honor, as I do not believe the people have met their burden here. Thank you, sir.
Thank you. Response to Mr. Milk's response from the people.
The people aren't saying it was a gun. The testimony is saying it was a gun. Our arguments aren't facts, the testimony is. Now, as to the strangulation, yes, her ability to breathe and her consciousness were not impaired, which is why it's charged as an attempt, not a strangulation. He tried to, when he, quote, put her in a chokehold and strangled her, which were the words the victim used. The testimony is that he applied pressure to her neck. He just wasn't successful in actually strangling her, which if he had given any impairment to breathing or consciousness, he would have, because then it would be the full strangulation, charged as attempt for a reason. That's to bind over is charged.
All right, so the standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being the lowest standard. The court does find that this occurred on December 21st, 2024, 3461 Bojardin Drive in the Apartment 3, City of Lansing, Michigan County, or that surrounding area. And so location, venue, and date have been proven at probable cause level. The victim, we have gotten into the statements concerning 768.27C. It was alleged by the victim that this was done by the person who she had children with, and identified as a DeAnthony Thomas Scott Van Atten, who has been identified in this courtroom as the person sitting next to Mr. Milks by Officer Zachariah Vanderwerf, who's had previous contact with Mr. DeAnthony Thomas Scott Van Atten. So identification is met at a probable cause level. And then the elements of the crime have been argued. This was statements made by Catherine Rose McGovern, Ms. McGovern, to Officer Peterson, indicating that she was placed by DeAnthony Van Atten, a person who he had a child in common and who had previously lived in her house in a chokehold. This is authorized as an attempt assault with intent to do great bodily harm, which being an inchoate crime places this as in half immediately. I find there is sufficient evidence to bind over that the defendant did attempt to commit great bodily harm, less than murder or strangulation in this matter, in that he placed the victim in a chokehold. There was a testimony that from Officer Peterson that there was no airway or strangulation, full strangulation, or lack of breathing, but there was evidence of a chokehold, and therefore the attempt charge would be bound over as count one. Count two, similarly, there was some of the cross-examination was based on the officer's testimony that was given to him by Catherine Rose McGovern during the 768.27C statements made to the officer that has been legislated in regards to making this case. Foundation was laid, 768.27C came in. The officer described that Ms. McGowan indicated to him that she saw the defendant place a blue handgun and clip into a bag. Those were the exact wordings. Whether this was, as indicated by cross-examination, a collection of airsoft guns, that can be proven at a later date. I can now say that can be proven at the trier of fact level. This is a mere probable cause level, and there is probable cause to believe in count two in count three, I should say, that the defendant was in possession of a firearm, to wit, a pistol, at the time he committed or attempted to commit the felony of firearm possession by a prohibited person, which goes to count two. And there is a stipulation after talking to Mr. Sumter that he was a prohibited person, and therefore he was in possession, pursuant to the hearsay testimony given to the officer, of a blue handgun and clip, and therefore count two is sufficiently bound over on location, offense, venue, ID, and date in regards to did possess a firearm when eligible to do so, when he was convicted of attempt R&O and was punishable by more than 1 year, and the requirements for eligibility had not been met. And then there's the question is whether he was actually in possession of a handgun. And I think the officer's testimony would indicate that it was described to him as a blue handgun and clip. specifically. At a probable cause level, I believe that can be bound over. Count 3 is bound over in the felony firearm, and then the misdemeanors of 4 and 5 will follow along with the notice. So I will indicate for the record that the examination was held on today's date, which is 3/28/2025, and it is bound over on the charges in the complaint. So Mr. Van Atten, your time in district court on this file, 25-00-00714 is complete. You'll be off to circuit court. Will you get your next date from your attorney, Mr. Milks, in circuit court? Anything else for the record on this file, 25-00-714, before I sign the bind over documentation, Mr. Pfeiffer?
Not from the people, Your Honor.
Mr. Milks.
Your Honor, we would like to make a bond motion. For simplicity's purposes, we'd probably just make one bond motion if the court would be okay with that,
Okay.
following the conclusion of the.
Absolutely.
Thank you, sir.
So if the court can just hold off on signing that bind over until
All
we're
right.
done with the other one as well, I think that should accomplish it.
All right, so I will await the bind over on that document to entertain a bind, if there is a bond modification pursuant to the second file, which is 25-00-701. And Mr. Pfeiffer, are you ready to go on 701?
Yes, Your Honor.
Mr. Mills.
Yes, sir. Thank you.
All right. I will, same rules for sequestration. You let me know and we'll make sure a witness does not watch another witness testify if they intend to be a witness in this matter. And Mr. Pfeiffer, you may proceed with your first witness.
The people will call Officer Barabanov.
This is on file 25-00-701.
Yes. With the stipulations that have already been put on the record, that should be the only witness I plan on calling in this file.
Right, Officer Barabanov, you can come up here. You can stand right in front of me and spell your first name and your last name for the record.
First name Ilya, Ilya. Last name Barabanov, Barabanov as in Victor.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do.
All right, you can have a seat. The microphone, as you know, is for recording purposes, so please project as best you can. And Mr. Pfeiffer, when you're ready.
Thank you. Yeah, we're still in the morning. Good morning, Mr. Barabanov.
Good afternoon.
Good morning, it's still before noon. Where are you currently employed?
I'm currently employed in the City of Lansing Police Department.
And what is your role there?
Road Patrol Officer.
How long you been an officer with the LPD?
It's gonna be 3 years in a couple of weeks.
So were you working in that capacity on March 3rd, 2025?
I was.
And on that day, did you end up being dispatched out to 3461 Yao Jardin Drive?
Jordan Drive, yes, sir.
Now, is that in Lansing?
Yes, sir.
Is that in Ingham County?
Yes, sir.
Now, what was the reason you were dispatched out there in broad strokes?
The caller, well, dispatch was for a fight.
Okay, so that's all I need for that question. So you're dispatched out there for an assault case. Did you end up speaking with a Catherine McGovern?
I did.
Now, as a result of speaking with her, did you determine that an assault had taken place?
I did.
Did you determine that assault had been domestic in nature?
I did.
Did you determine that assault had taken place recently?
I did.
And by that, we mean within a couple hours at least, right?
Yes, sir.
Now, were you fully wearing your police officer uniform?
I was.
As a result of talking with her, did you determine that she had been the victim of that domestic assault?
I did.
And did you observe any injuries on her?
I did.
And what were those injuries?
There was a fresh mark on the right hand. There was visible, still like fresh blood. There was some sort of scratch or laceration.
And did you also observe property damage there?
I did.
Now, the injury that you saw on her and the property damage you observed, did these seem to match up with what Ms. McGovern told you happened in this assault?
Yes.
Your Honor, at this time I'd seek to proceed under MCL 768.27C, as I believe there's been a sufficient factual basis laid, as well as for subsection D, circumstances indicating trustworthiness.
All right. So 768.27C, motion to admit hearsay in regards to that statute. Mr. Milks has had an ongoing objection during the first file Mr. Milks, is there, you have an ongoing objection to the second file, I'll allow you to make an argument.
Thank you, sir. Your Honor, there's no actual evidence on the record that was laid a proper foundation. There were only conclusions made. It's the equivalent of me going to this officer saying, do you authenticate this photo, sir? And him just saying, yes, I authenticate. It's not a proper way of doing it. I mean, obviously, the officer didn't do anything wrong, but it's improper. It's poor foundation. And Your Honor, I ask that it not come in. Otherwise, I would just like to renew my previous objection from the prior file. That'd be okay, Your Honor?
That's fine. And there was objection to foundation and then trustworthiness being an issue. Mr. Pfeiffer response.
I believe that it is a sufficient foundation that was laid while avoiding eliciting the hearsay testimony before actually getting into it. Again, I've tried it every way that I can, and each time the public defender's office gives a new and different objection saying that it should happen the other way. Every time. So this is the best way that I've been able to find.
I don't know what everyone else is arguing, but I know that I'm right compared to my other people in my office.
All right. That's a fair statement. I find a sufficient foundation has been laid on 768.27C by the questioning of the officer. The statement purports to narrate, describe, or explain the infliction or threat of physical injury upon the declarant. The action in which the evidence is offered is involving a domestic violence altercation, which the witness has testified to. The statement was made at or near the time of the infliction or threats of physical injury. We're dealing with a couple of hours here at most. And the statement was made to a law enforcement officer. And the officer indicated that he was in full uniform and working as a police officer. There is an element of trustworthiness that's included. I have no information that this statement was made in contemplation of pending or anticipated litigation in which the declarant was interested. I don't have that information at this point. I'm assuming the declarant may be biased for making the phone call, but I can't assume anything more than that. So there's nothing to indicate that they're fabricating the statement or extent of bias or motive, and where the statement is corroborated by other evidence has been corroborated by observing physical injuries on the complaining victim as a result of whatever fray or fight that the officer was responding to. So for that purposes, I'm allowing the domestic violence statements to come in pursuant to 768.27C. In regards to this file at preliminary examination, of course, there's a confrontation issue which goes as to the trial level, but it does come in for purposes of the preliminary examination. So Mr. Pfeiffer, you may proceed.
Thank you, Your Honor. So, Officer Robinoff?
Yes, sir.
Did Miss McGovern tell you who had assaulted?
Yes, sir.
And who did she say had assaulted?
Anthony Van Atten.
Did she say how she knew this Anthony Van Atten?
They were in a relationship since 2022, and they have 2 kids in common.
Your Honor, with that testimony combined with what has already been stipulated to, I would ask that the court find that identification has been made through a combination of those 2 factors of this defendant as Anthony Van Atten.
All right. Any objection to the court finding identification based on the testimony in the other file, and that it was stipulated to of Officer Vanderwerf, who was called for the sole purposes of identification? Mr. Milks.
Thank you, Your Honor. Yes, Your Honor. There is still the ongoing objection we've got regarding identification. If I may voir dire this witness, Your Honor.
You may.
Thank you. Sir, did you arrest anyone on the scene that day?
No, sir.
And were you involved with a photo identification of this Mr. Van Atten person?
What do you mean by photo?
Did you have the complaining witness here, Ms. McGovern? Did you have her do a photo identification?
No.
Was she at any time pointing out who did this to her?
No, it was just me and her there.
Okay. Thank you, Your Honor. No further questions.
Right.
So then just regarding my objection, Your Honor, there's been no actual in-court identification of my client, understanding the other officer's testimony, Your Honor, but there's no indication that my client is the actual one to commit this crime, Your Honor. The witness, or the complaining witness in this matter, has not gone through any identification process other than giving us a name. It's not proper to say that my client is involved in actually committing this offense. I'm renewing my previous objection from earlier. And once again, Your Honor, just saying that this is unduly suggestive because just because my client is sitting here does not mean that this is the same Anthony Van Atten who actually committed this offense, Your Honor. We have no actual witnesses or identification of my crime being implemented in this crime. Thank you.
Thank you. Mr. Pfeiffer response, and then I have the officer indicating that Catherine McGovern indicated that the assault was committed by a DeAnthony Van Atten, a person who she had been in a relationship since 2020, and a person who she had children in common with. That's what I have from the officer.
Your Honor, I believe there's sufficient factual basis for identification for preliminary examination purposes to a probable cause standard. Same victim, same defendant, same location, same relationship, same children, same charges, same arrest, same face. I'd ask that you find identification.
All right, so the court defines that the stipulated testimony as to DeAnthony Van Atten concerning Officer, let me grab that other file. Officer Van, I'm gonna have trouble with that name. Officer Vanderwerf has been stipulated to that the present person identified is DeAnthony Van Atten. I will find identification has been met at a probable cause level by this person who is in the courtroom now, is the same person who was identified by Officer Vanderwerf as DeAnthony Van Atten. I should say DeAnthony Thomas. I should say DeAnthony Thomas Scott Van Atten in this courtroom, and that testimony has been stipulated to. It comes in for this file, which is file 2500701. And then Mr. Pfeiffer, you may proceed.
Thank you. So I'd like to get into the actual assault components of this. What did Ms. McGovern tell you happened during this assault? How did this start?
The argument started because they got into an argument because the victim decided to tell the accused that he needed to leave over the last 2 weeks of verbal abuse. She said she had enough. The argument started because she told her to leave. They started arguing. They went upstairs. He started packing his things. The firearm that was laid by the accused on the table was in the room.
She said that she saw a firearm
Yes.
and that he had that firearm.
Yes.
How did she describe that?
It was a black handgun with an extension from the magazine dwell, which would indicate that it's an extended magazine.
Okay, so she saw a handgun here. What did she say happened next?
So she said she turned around. The next second, the accused was on her, behind her, with a gun barrel to the back of her head.
And what did she say happened once he had the gun barrel to the back?
She said she was fearing for her life, that the accused had the finger on the trigger. She didn't move. She didn't do anything. The accused then eventually let go.
Did she tell you if he said anything during that time?
Can I read my report for the court?
Well, is it difficult to remember that point at this moment?
Yes.
Would looking at your report, do you believe would help refresh your memory to that?
Yes, sir.
Okay, then if I could approach, Your Honor.
You may, and I'm assuming that Mr. Milks has been shown the copy of the report.
Yes, Your Honor. Thank you.
The copy, all
Clean
right.
copy. I always make sure I have a clean one. So, Officer Barabanov, I'd like you to look at this. You can read it to yourself silently. Please don't read it aloud until you feel it's either sufficiently refreshed your memory to this point, or you find it's just not going to be possible to do so. When you're finished reading that, let me know. I'll take it back from you, ask you the question again.
I'm ready.
Also, if I may approach. Thank you. Now, officer, did that help refresh your memory to that question?
Yes, sir.
Okay, so did Ms. McGovern tell you if he said anything during that time?
Yes, she did.
And
She said that he said he should just kill her.
while he had the gun pressed to the back of her head?
Yes, sir.
What'd she tell you happened after that point?
He eventually let go. She went downstairs and called the accused's mother to tell her what happened. She went downstairs, sat on the chair in the dining room. She said she was going to call 911 when the accused came downstairs, breaking another TV or pushing another TV off its stand. the accused attempted to hit the phone out of the victim's hand, and then the fight happened, ensued between the both, where they both ended up on the ground. The accused eventually got the phone from the victim, threw it down the ground where it broke the back of the phone.
Now, did you personally see this phone yourself?
I did.
Were you able to confirm that there was damage to it?
Yes, sir.
Now, she said that she was calling 911 and he then got the phone from her.
Yes.
Okay. Now, did you see him there at the scene?
No, sir.
Were efforts made to locate him that day?
Yes, sir.
And were they successful?
No, sir.
Now, did she say if the children were present?
Yes, sir.
Do you end up notifying CPS?
I did, sir.
And that's department policy, right? When assault happens around children?
Yes, sir.
And to be clear, she said this happened at that address you were dispatched out to, 3461 Yo Jordan,
Yes, sir.
and that's in Lansing, Ingham County.
Yes, sir.
Your Honor, I don't believe I have any further questions for this witness.
All right. Cross-examination, Mr. Milks.
Thank you, Your Honor. Good afternoon, sir. Were you present during this alleged assault?
I was not present.
Did you arrest anyone that day from related to this assault?
No, sir. I did not arrest anybody.
Were you aware of another CPS investigation regarding Ms. McGovern and this Mr. Van Atten person?
I don't recall any other investigation.
And were you involved in any sort of CPS investigations related to this offense specifically?
Other than making a CPS referral.
So you did make a referral to
Yes.
CPS? Okay. And did they, if you know, did they follow up with an investigation?
Wish I could tell you the answer to that.
Did you find a handgun in the house?
No.
Did Ms. McGovern point you to any other handguns in the house?
No.
Did you see this handgun that she's alleged at this point?
No.
Do you know if it was an operable handgun?
I wouldn't know.
And would you know if this was like an airsoft gun?
Not without looking at it.
It can be hard to tell. Airsoft guns can look pretty similar to real guns, fair to say?
That is fair to say.
All right. And there would be no way of you knowing whether or not this was a real gun or whether this was an airsoft gun, fair to say?
Fair to say.
Okay. Thank you, Your Honor. No further questions.
All right, Mr. Pfeiffer, any redirect?
Very briefly. If you were to put an airsoft gun to the back of someone's head and pull the trigger, could that kill them?
Depends.
Do you think it's likely that an airsoft gun is able to kill somebody from a airsoft pellet?
Not that I've heard.
How about a bullet?
100%.
Thank you. I have no further questions.
All right. May this witness be excused from the people?
You may, Your Honor.
May this witness be excused from the offense?
Yes, sir. Thank you.
All right, you're all set, sir. Thank you for your appearance today.
Council's going to need the requested ad account under the B for interference with traffic.
And then the testimony there's a stipulation that Mr. Van Atten was a person prohibited to carry a firearm pursuant to the testimony, Mr. Sumter. That's been stipulated to per this file. Is that correct?
Yes, Your Honor.
Mr. Milks, is that my understanding?
Yes, Your Honor. Again, which just was my ongoing objection there.
Okay, thank you. All right, any further proofs for 25-00701, Mr. Pfeiffer?
No, Your Honor, people rest.
Okay, any proofs today concerning 25-00701, Mr. Milks?
Your Honor, again, the people, or I'm sorry, the defense would like to call Ms. McGovern in this matter is just for the reasons earlier stated, Your Honor. She's not a missing witness at this point. We're more than happy to do an adjournment, waive the 21 days, Your Honor. And I mean, at this point, I think her testimony is going to be necessary as there's nothing defense can do when someone's just reading from the report essentially like that. It's shooting fish in a barrel. So there's no actual voir dire going on, no actual seeking of justice or truth here, Your Honor, because we're just hearing what officers are parroting from an individual who I've had no opportunity to question. So we would like to be here, Your Honor. I think it's necessary.
Thank you, Mr. Milks. Response, Mr. Pfeiffer.
Oh, same arguments as before. This is a probable cause finding.
It's probable cause finding based on probable cause at preliminary examination. The legislature has placed 768.27C as being the legislatable purpose for statements coming in through the officer on sufficient foundation for domestic violence cases. That is still a confrontation issue if this makes its way to circuit court. This is a preliminary examination, so it's a probable cause issue. So the hearsay statements were allowed in. And so I understand the objection. The objection is noted, and the people may make their motion for binding.
Thank you.
And I'm denying the adjournment of the matter for getting the witness here.
Thanks, sir.
Your Honor, I believe there's sufficient factual basis to bind over for count 1, firearm possession by a prohibited person, as this was described as a handgun, even with an extended magazine, and also leading evidence to the fact this is a firearm and not a airsoft pistol, which again, there is absolutely no testimony that the defendant even owns an airsoft pistol on this record. It is only with the defense attorney's questioning, which is not evidence. He had it pressed to the back of her head and said, "I should just kill you," which again, pretty difficult feat to do with an plastic airsoft BB. Significantly easier to do with a bullet from a firearm. His own statements to the victim, the threats he was making at that point, are evidence that this was a firearm, a functional, working firearm that he threatened her with. Which also leads me to count 2, which I believe there's sufficient factual basis to bind over on that as well, as he threatened her and assaulted her with this handgun. Count 3, interfering electronic communications. I believe there's sufficient factual basis for this as well, as the testimony was. She was trying to make a call to the police. She told him, "I'm calling police." And he tried to just smack it out of her hand, and when that wasn't successful, wrestled her to the ground and grabbed the phone and damaged it, as the officer testified to. So there is sufficient factual basis for that count as well. Both of the felony firearms, count 4 and 5, I believe should be bound over based on the testimony. Count 6 is a misdemeanor, automatically carries over. And the people are requesting an additional added count 7, that being interfering with a crime report by committing a crime or threatening to kill or injure. The PAC code being 750.483A2B as in boy. And I realized that there was this count during that testimony, particularly when he said, Ms. McGovern told me, she said she was going to call 911. She was going to call the police. And that's when he was working to get the phone out of her hand. And he successfully did so. So there is a sufficient factual basis to bind over on a requested added count 7 under the theory that the defendant did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person, and the violation involved committing or attempting to commit the crime of interfering with electronic communications. And as I've said many times before, as I have these 2 charges bundled up together quite frequently, there is no double jeopardy issue here, as each count has an element that the other one does not. As interfering with crime report requires that the person trying to contact is police or emergency services, and interfering with electronic communications requires that you're interfering with authorized communications through an electronic medium, which is not a requirement for the crime report. I'll preempt this because I fully understand how that seems on the surface, but there is no double jeopardy at issue here, which is why it's often used. So I would ask that you bind over on the initially charged counts 1 through 6 and the requested added count 7.
Thank you. A response, Mr. Mills.
Thank you very much, Your Honor. Your Honor, first and foremost, just regarding identification, again, identification must be one that it was probable cause to believe that it was my client observed doing this, or that my client is identified as the individual doing this. Those things there's no nexus between these two, Your Honor. It was argued that this must be the same face, same person, same kids, same clothes. Nothing on the record here has indicated that this individual here is that person who has the same kids, same face, same clothes. There's been no pictures. The court has nothing to compare it to. And I just renewed that objection here, Your Honor. Regarding the double jeopardy issue, Mr. Pfeiffer is absolutely correct. There's a different there is a different element for each offense. However, double jeopardy doesn't just incorporate the offenses being the same, Your Honor. It also incorporates twice being penalized for the same offense. By way of mere illustration, Your Honor, anytime a person would commit a CSC first, they would automatically commit a second, third, and fourth. Just by the nature of those offenses, prosecutors are prohibited from charging for a single sexual act 1, 2, 3, and 4. We have a single act here, and the prosecutor is trying to part and parcel this one act into multiple offenses, which they cannot do in these circumstances, Your Honor. This isn't like felony firearm, which is allowed to attach onto another offense, Your Honor. He is twice being punished for one single act. To further illustrate this, Your Honor, in the previous hearing regarding bindover, this court, and I think very wisely, saved the prosecutor by saying that, look, there were two, I'm sorry, not this case, but Granado, there were two separate acts. There was a stabbing of the face, there was a stabbing in the leg, because the court was recognizing you need two separate acts there. I'm asking the court not add on this additional count because, again, my client is being placed in double jeopardy for being twice punished, Your Honor. For those, additionally, Your Honor, regarding the gun, I have zero burden here. I have nothing that I need to show or nothing I need to prove. The people have not presented this court with a gun. They've provided with a statement. We've got no basis for understanding her knowledge of weapons, her ability to opine on weapons. Illustrating that, Your Honor, was bringing up the airsoft, where even this officer couldn't say one way or another whether or not there was an actual handgun there. Your Honor, it is the people's burden. They are the ones who have to put evidence on the record. They have not, Your Honor. I'd ask that the court not bind over on the gun charges as well. Thank you, Your Honor.
Thank you, Mr. Pfeiffer. Response.
Yeah, I'm glad I was here for the actual argument on that other case that I was not the prosecutor on, because the defense's depiction of it is not applicable at all to these charges. Because in that case, the court was determining two different incidents because there is a GBH and a felonious assault, which specifically says as its elements without intent to inflict great bodily harm. That is not analogous at all to these facts. What is more is if he strangles his partner, he is guilty of strangulation as well as domestic assault, because each has an element that the other does not. If he's holding her down while he's doing that, it's unlawful imprisonment and strangulation and domestic violence.
Noting my objection.
Objections noted.
If he breaks into the home, holds her down, strangles her, it's home invasion, unlawful imprisonment, strangulation, domestic violence for what is considered one act. Because that's what the law is. So I'd ask that you bind over as requested here with the initially charged counts 1 through 6 and the requested added count 7.
As to file 25-00701, I find that this all occurred on March 3rd, 2025, at a probable cause level, probable cause being the second lowest standard in criminal law, reasonable suspicion being the lowest level. I find that the date of March 3rd, 2025 has been proven at a probable cause level. This involves the statements made by a Catherine Rose McGovern to Officer Barabana in regards to 768.27C, and therefore the date of the offense and the venue of location, the location being 13461 Beaujardin, Apartment 3, City of Lansing, Ingham County, State of Michigan, has been met at a probable cause level. The identification was previously made by Officer Vanderwerf. Officer Vanderwerf. And that was stipulated to that Catherine Rose McGovern indicated to Officer Barabana that DeAnthony Thomas Scott Van Atten was the person who inflicted the assault and the person who identified in this matter by herself. That was identified by Vanderwerf as the person who was sitting in the courtroom, DeAnthony Thomas Scott Van Atten. I believe that meets identification purposes for purposes of this prelim in regards to probable cause at a probable cause level. Also, I would note that this information was gotten from Officer Barabanoff by Catherine Rose McGovern, who has been in a relationship, this is according to Officer Barabanoff, since 2020 and has children in common with DeAnthony Thomas Scott Van Atten. That was told to Officer Barabanoff pursuant to 768.27C. So with that understanding, it was indicated and stipulated that DeAnthony Thomas Scott Van Atten, the defendant, is a person who is prohibited to have a firearm. The firearm was described in this instance as a firearm, which was described pursuant to the officer's testimony, and with an extended mag. So I find there's probable cause evidence to find that DeAnthony Thomas Scott, not only in the description of the weapon in which he was in possession of, but then the following, he goes and he places the gun to her back of her head and indicates that I should kill you. All of those would indicate that this was a firearm. This was not a paintball weapon. That's to be determined by the prior fact at a different standard of evidence, a different standard. But I find for counts 1 and 2 that he did hold the gun to her head based on her statements made to the officer, and that he did threaten her with a gun indicated. And so count 1, possession of a prohibited person. He was prohibited from having a handgun. The testimony was that he was in possession of a handgun, actually used the handgun in a felonious assault. And therefore, I find probable cause to believe that count 1 has been proven at a probable cause level. And I will bind over on count 1 as the defendant is charged with did possess and use a firearm when ineligible to do so, because he had been convicted of attempt R&O, and it had not been more than a year, and requirements for gaining eligibility had not been met. Count 1 is bound over. Count 2, Ms. McGovern indicated to the officer that he pointed the dangerous weapon at her head and threatened to kill her. So I would find in count 2, as made at probable cause level, that the defendant did make an assault upon Catherine Rose McGovern with a dangerous weapon, to it a pistol, but without intending to commit the crime of murder, inflict great bodily harm. Contrary to 75082, I find there's probable cause to bind over on that level on March 3rd, 2025 at 3461 Beaujardin, Apartment 3, Lansing, Mission 48910, based on Officer Barabanoff's testimony. In count 3, there was a fight over the telephone once there was an indication that there may be a call out, and we'll talk about that later. But it does feel that count 3 is being met at a probable cause level, that the defendant is accused of interfering with the electronic communications on March 3rd, 2025 at 3461 Beaujardin, Apartment 3 in the city of Lansing, in that Officer Barabanoff did indicate that the gun was once slapped at and then taken from the victim in the matter, based on statements she made to him under 768.27C, and did willful and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication or through a telephone or telephone line, essentially interfering with electronic communications. I find there's probable cause to bind over on that. Counts 4 and 5 are the 2 years of felony firearm, that he was in possession of firearm during the possession of by a prohibited person, and the assault dangerous weapon. Since those two have been found in probable cause level, and one of them indicates that he was in possession of the firearm during both those instances, both 4 and 5 are bound over at a probable cause level, that this did occur on March 3rd, 2025 at 3461 Beaujardin, Apartment 3, City of Lansing, State of Michigan, and that the DeAnthony Thomas Scott Van Atten was identified by Catherine Rose McGovern as the person responsible for count 4 and 5. So counts 4 and 5 are bound over. Count 6 is bound over as a misdemeanor to follow. And then there's a request for count 7. And I've read a little bit on this concerning whether the double jeopardy does apply. It comes down to the Blockberger test, as do the elements suggest that they are the same elements. That's what double jeopardy comes down to. There's an argument to be made that they are preventing the same wrong. Essentially, double jeopardy was so we couldn't go, so we couldn't be tried for the same offense by the same king. And so we essentially said, you can't try us once we've been found adjudicated on those facts. How did we find what facts were adjudicated? We went to the Blockberger test and we indicated that is the elements, and that is the elements in this offense pursuant to 750.483.825. The Court of Appeals has kind of ruled on this, that these are separate offenses. One is really the communication through an electronic device of a telephone or cell phone. One is interfering with a witness, so it can be used not only in 911 case, but it can also be used in another case, in prohibiting a witness to contact another witness, or prohibiting a witness to contact in any regards anything that would interfere with a witness testifying for a certain matter or interfering with a certain process. I find that probable cause has been met as to count 7, the interfering with a 911 call under pursuant to 750.483.825B. That is the 911 electronic device. I do not find at this level that there is a double jeopardy issue. And so count 7 is bound over as requested. And then the habitual offender notice will also follow. So I will bind over on counts 1 through 6, and then we'll add a count 7.
And before the signature, I just want to remind that the defense wanted to make a bond.
Correct. 750.48382B. And so it's 750.48382B. I will write the same on the bind over notice. So the examination was held on today's date, which is March 28th, 2025. And it's been bound over on the charged complaint with an added count 7 of 750.48382B, which commonly referred to as interfering with a witness's testimony. And that was being the 911 call. So I'll bind over on count 7, and the offense notice is to follow. We do have, before I sign the bind over documentation, on 2500701, and then there is a motion to be heard on 2500714. Mr. Milksy, would you like to be heard on bond on both of these files?
Yeah, yes, Your Honor, if I may just do one argument that, and I just want my record to be clear here, Your Honor. I agree with the court regarding double jeopardies, the court's analysis regarding double jeopardy and the Brandenburg test. I wasn't bringing it under the Brandenburg test under the 3 related protections of the 5th Amendment. We were doing so under the 3rd, where it protects against multiple punishments for the same offense, not under Brandenburg. And this comes from People v. Nutt, 469 Mitch, 565, 2004. I completely respecting the court's ruling. I'm not asking for a reconsideration.
Right.
But Your Honor, regarding bond at this point, my client is currently, sorry, I'm trying to pull the file.
25K.
Thank you. 25,000 cash surety on both files, Your Honor. And in this matter, my client's asking that he be given a reduced bond, significantly reduced bond, Your Honor, even if the court would consider a PR bond, understanding the nature of these offenses here. Your Honor, I've known Mr. Van Atten for quite some time. I like to think I'm somewhat of an upstanding member of the community. While I'm not going to 100% vouch for him, obviously, because I don't know him that well, I will say, Your Honor, that he has always appeared in court. He has always shown up. He is not a flight risk, and I don't believe that he's going to be, having had that opportunity, Your Honor. Furthermore, Your Honor, I believe any concerns this court may have regarding his potential threat to the public or concerns the court may have, I think can be alleviated with a GPS tether, obvious restrictions as to where he can or can't go. I think one of the hard things here too, I also know Ms. McGovern, Your Honor, as my client and her have been dating for quite some time. For my client to be able to actually out be working, helping the family, providing for the family, they do have children together, Your Honor. Obviously, he would not be allowed to have contact, but it's help. Money going to the home is not, I wouldn't believe would violate at least the spirit of the no contact order, so long as there's obviously no communication, Your Honor, but being able to help provide for the family here, Your Honor. For those reasons, Your Honor, I'd ask that the court would consider a significantly reduced bond, a 10% or even a PR bond. Thank you.
Thank you. Mr. Pfeiffer.
He literally failed to appear for the sentencing for his attempted result. Oh my God. Assault, resist, obstruct of the officer that he was convicted of. A bench warrant had to be issued and his bond was forfeited, and that was just in November. So he does have a history of failing to appear. And his charges have actually increased. The highest one that he was facing, apart from the mandatory consecutive felony firearms, were the 5-year felonies in each, or 7.5 with the habitual offender. Except added count 7 is a normally 10, but now 15-year discretionary consecutive felony. That is not cause for a reduction of bond. If anything, it gives me license to ask for an increase. I'm not, though. I'm asking that it remain where it is.
Okay. All right. The bond was set at 25,000 cash surety per 25,00701 and 25,000 cash surety on 25,00714. This was set by the magistrate, who have been somewhat critical of concerning her bonds. I'm going to leave this bond as the same. So the bond is set at $25,000. I deny the motion to reduce bond. I will not modify bond, keep the bond as is at 25,00701, and I will sign 25,00701 accordingly. So you should get your next date on that file from your attorney, Mr. Milks. I will also sign, which is also 25,000 cash surety, a bond that's set by the magistrate at 25,000 cash surety. I would not modify bond. I'll deny the motion to reduce bond, and I will leave it at 25,000 cash surety that was set previously by the magistrate. So your time in district court is done on 25,00701 and 25,00714. You'll get your next date on both of these files from your attorney, Mr. Milks, in circuit court. Anything else for the record on either one of these files, Mr. Pfeiffer?
Not on behalf of the people.
Mr. Milks.
Just the court's aware, when I was speaking regarding Mr. Van Atten, my experiences with him, I didn't know about the R&O. I wouldn't represent him in that case. I just hope the court knows it was based on my experiences with him. So I just, thank you, sir, for acknowledging me. Nothing further for defense.
All right, thank you. With that understanding, that's all for both of those files. Thank you for your appearance today.
Thank you, Your Honor. Rob, do we have any information?
I do have some information.
Or are we a cuckoo there?
No, I have some information.
Oh,
Maybe
You guys want the
real
transcript?
quick or talk to Judge in Chambers.
All right, so we're on the record in docket 25-00590. That is People of the State of Michigan versus Tavel McLean. Will the parties please introduce themselves for the record? Mr. Pfeiffer.
Good afternoon, Your Honors. This is Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Tavel McLean, the gentleman who stands to my right.
And sir, you are Tavel Iris McLean, is that correct?
Yes, Your Honor.
Thank you. This is time set for a preliminary examination today. Mr. Pfeiffer, how are we proceeding? My understanding is there's going to be a request for an adjournment and maybe a motion.
I'm going to leave this to Mr. Palmer.
Okay, Mr. Palmer.
Thank you, Your Honor, and good morning or good afternoon, excuse me. At this point, my office has identified a potential conflict that needs to be further investigated. My concern, obviously, is that if there is a conflict, I want Mr. McLean to have the absolute best representation that he can get. To be clear, this is not Mr. McLean's fault. He and I have been working quite closely together. We have no issues whatsoever with each other. That said, I am concerned about this potential conflict. As a result, I think that the court probably, I don't think it's ethical for me to proceed at this time with conducting a preliminary exam on behalf of Mr. McLean due to the potential nature of the conflict. I would ask that the court find good cause to adjourn. I would also like to address bond, given that this issue is not in any way Mr. McLean's fault.
All right. Mr. Pfeiffer, have you had the opportunity to contact any witnesses in this regard for the adjournment, for an adjournment purpose?
Yes, per the in-chambers conference, I did call off the witnesses so that they didn't need to come out here because the people are in agreement that just per the ethics rules that it's pretty clear conflict counsel is needed.
All right. So I will agree to an adjournment in this matter based on the potential for conflict and maybe to look at conflict counsel because we still have to look at conflict counsel, which would probably be the safest route for the public defender's office to seek conflict counsel in this matter. And so I'll adjourn for just cause. I find this is a good reason to adjourn. So we won't be asking you to waive any of your rights. We'll adjourn the matter to
May 1st at 1:30.
May 1st at 1:30. So adjourn to May 1st at 1:30. And then, Mr. Palmer, did you want to be heard on bond?
Real quick, just so that for the record, there's a good chance I'm going to be in trial. We can still do that date. I don't want it being adjourned due to my incredibly busy schedule for the next 3 months. I just might have someone else need to cover.
All right, we'll wait to hear if that May 1st date is acceptable.
It's acceptable to the people.
Yeah, we just have to make sure that if there's conflict counsel, we get, because that takes some time also, is my understanding.
I understand, yeah.
Okay. All right, so we'll keep that date. And then, Mr. Palmer, did you want to be heard on bond?
I do, Your Honor. I would ask that the court consider releasing my client on bond, either a personal recognizance or if the court doesn't feel comfortable with the personal recognizance, some low 10% bond. Mr. McLean obviously enjoys a presumption of innocence in this matter. We've not even taken any testimony or seen any evidence regarding this. So other than the charges, which Mr. McLean faces at the moment. We already have had an adjournment once in this matter. We are now, that adjournment, just by way of reminder, that adjournment previously was not attributable to Mr. McLean. This adjournment is also not Mr. McLean's fault, I guess I will put it that way, by any means. Mr. McLean does have a local address. He's been in this area basically his entire life. My understanding is that he's got no prior failures to appear. He does have stable housing. He does have a stable job. I don't believe that, and certainly Mr. McLean understands that there is a no contact order in place with the complaining witness in this matter. I'm asking that the court, because we're now adjourning at this point, a prelim out to several months, through none of which has been due to Mr. McLean's fault. I'm asking that the court consider a personal recognizance bond for Mr. McLean.
Thank you, Mr. Pfeiffer.
Well, to be clear, the first delay was Mr. McLean's fault because he was violating no contact order, was contacting the victim and telling her to use different text now numbers and to basically evade detection in order to talk to her. And that is not a new practice for Mr. McLean. Because I have a habit to my detriment of forgetting to delete things from my computer, I'm able to see the last case I had with him in 2023 and all of the times he called the same victim in those cases to get her to recant and to not appear and testify. So given that fact, I don't believe that a PR bond is appropriate, despite the fact that this delay, this newest delay, is because of a conflict that is not his fault. The reason that we couldn't do this last time was because of him and his actions. So I do not believe that a reduction of bond is appropriate.
Judge, just to follow up on that. When I said it wasn't his fault, the other issue that came up at the prior preliminary exam date is that neither the prosecutor or I had any body camera whatsoever. So you're right. So I don't mean to, I think Mr. Pfeiffer had someone else cover for him. So it's not Mr. Pfeiffer's fault either. I'm not suggesting that. I'm just saying there was a discovery issue that was not due to Mr. McLean's conduct that required a delay regardless.
My mistake. Mr. Palmer is absolutely right. So I think it would be more appropriate to say that that delay was not solely Mr. McLean's fault.
And I think that's a fair statement. My notes indicate there was some outstanding discovery, and then there was an additional PA 53 violation. That is the no contact order. I set bond. I personally set bond at 100,000 cash surety concerning this matter. There was a request by the people was set for 450,000 cash surety for various reasons. I don't see. I think counsel is correct that today's date adjournment is not due to the fault of Mr. McLean. March 14th adjournment, there's some fault that goes towards not some outstanding discovery, but there was a no contact order. I will indicate for the record that previously, as of 2011, there was a conviction of assault with intent to great bodily harm in the 30th Circuit Court of Ingham. There was also January of 2009, a 30th Circuit Court of Ingham interfering with electronic device, and then a flee and elude third out of 2008. Based on the history, I believe that 100,000 cash surety is still the best bond for this matter. So I will deny the motion to reduce bond or modify bond. Or modify, and we will set bond at the continue bond at the $100,000 cash surety.
Thank you, Your Honor.
Anything else for the record in 2500590, Mr. Pfeiffer?
Not on behalf of the people, Your
Mr.
Honor.
Palmer.
No, Your Honor. Thank you.
All right, we'll see you on May 1st at 1:30, Mr. McLean. Thank you for your appearance today.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
I do not want to get in the court's way of being able to actually eat food and have Wendy's survive. I have Brooks at 1:30. I'm not going to go anywhere when the court's ready, and
it'll probably be an hour, I bet.
Okay, I
So-
can come back
Yeah.
in an hour, so I can also get some stuff.
Yeah, you can get some substance.
All right, perfect.
Yes. We are on the record in docket 2403-427. That is people of the state of Michigan versus Andrico Brooks. Will the parties please introduce themselves to the record? Mr. Pfeiffer.
Yes, good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Mr. Freeman.
Thank you, Your Honor. Stephen A. Freeman, Public Defender, on behalf of defendant who is seated to my right.
And sir, you are Andrico Brooks, is that correct?
Yes.
Thank you. This is the time set for a adjourned preliminary examination request for bind over. We previously started this in, let's see, December 19th, 2024. That was session 1. We'd taken testimony and then we adjourned February 7th, 2025. That was session 2. And then at the request of the court, we had the opportunity to put those all to transcript so we could see the first 2 sessions and then request a bind over, and that's what we're here for. So I would assume that that previously indicated there are no further proofs concerning this matter of Mr. Pfeiffer. Is that correct? I think you previously rested. I just don't remember.
That is correct, Your Honor. No further proofs.
And if I remember correctly, Mr. Freeman, there was no additional testimony to be taken. The prosecutor was going to rely on the proofs that had already happened and then motion for bind over. Is that correct?
Yes, Your Honor.
All right. All right. Motion for bind over, Mr. Pfeiffer.
It's going to be very similar to the last time we were here, though, as I said shortly before we began, and I gave an updated printed off requested additional counts. The second CSC first, what was previously I request count 14. Upon speaking with defense counsel and looking through the transcript, that one would not be appropriate to bind over as the facts were not there for that. I was frankly confused because of the video that was found on the phone by Detective Raymond where he was having sex at gunpoint with a different woman, but that wasn't the victim, and therefore it would be inappropriate to charge. But I'm going to take these in order.
All right.
And for ease of the court as well as the defense, before today, I went through and quite literally put notes of what page the evidence for each of these counts is on.
All right.
So first, for count 1 of torture, the amended date of offense would be May 25th, 2020. This is found in volume 1 on pages 29 to 31. And then also in a couple other places. But this is in the May 25th, 2020 incident where the defendant not only strangled her, but was trying to slit her wrists with, I think it was nursing scissors. Punching, slapping, choking, slamming her head into the walls, punching her legs, giving her bruises all up and down her legs, her arms, and had been trying to, again, slit her wrists with these scissors. On top of that, what was talked about further on in this is that from a prior incident, her ribs were actually broken and he was intentionally punching the broken ribs. And frankly, Your Honor, I believe that that qualifies as torture. And so I believe there's sufficient factual basis to bind over for count 1.
And that's still the 1701 Millstone address.
Yes, Your Honor. Now, the next counts are several counts of strangulation, suffocation, and great bodily harm. I'm going to take these again, one at a time. So first of all, for count 2, for this, I would look to page 29. And again, the date of offense would be 5/25/2020. Where the victim says that he put his hands around her throat and that he started choking her, that she was unable to breathe. And so I believe there's sufficient factual basis for count 2, assault by strangulation. Then count 3, the other count of assault by strangulation. This one, the date range would simply be for 2020. And I would be looking at page 37.
So is that for the year 2020?
Yes, the year 2020. And page 37, where she talked about going to the grocery store, him telling her that she couldn't go. And when she said she was going to go anyways, he choked her to the point where she passed out. When she woke up, he was hitting her in the mouth and in the face. And so I believe a sufficient factual basis to bind over for count 3, assault by strangulation. Then we go to count 4. Assault intent to do great bodily harm, less than murder or by strangulation. And it is currently charged with the great bodily harm. Frankly, can either stay there or can also change to the alternative theory of strangulation. For this, I would be going to page 43 with a time frame of June 2020. Where she talks about how she went to his house on a break from work and that he punched her in the face and was choking her again to the point of unconsciousness. And so I believe that that is a sufficient factual basis for count 4.
That's still the Millstone address.
Your Honor, I would amend that to just be inside Ingham County. It was at Mill Pond, which is a trailer park there. This was at his location, but we still established, and again on page 43, that that location was inside Lansing, inside Ingham County.
So it's inside Lansing.
Then for count 5, assault intent to do great bodily harm, less than murder or by strangulation. This would be going to page 62. And we are talking about 2020 is the date range. This is before May, but she wasn't clear about what point in the spring. And this is the incident where he was punching her in her ribs back to back to back to the point where you could see the bone crack through her skin. She knew that the rib was broken. He kept swearing up and down, no, the rib's not broken, and kept deliberately punching her there, which I believe is clearly a sufficient factual basis for intent to do great bodily harm less than murder. So I believe a sufficient factual basis for count 5. That count 6 is a misdemeanor, which just carries over. And then we get into the requested additional counts. The additional count 7 is home invasion in the first degree. And for the factual basis, I would be looking at page 29, where it says that he followed her back into her house and barged into the house and started attacking her. Therefore, I believe that is a sufficient factual basis to bind over on that, with the date of offense being 5/25/2020. And as said before, the PAC code for this is 750.110A2. Then we move on to the requested count 8, interfering with a criminal report by committing a crime. Date of offense 5/25/2020. PAC code 750.483A2B, where the defendant committed the crime of interfering with a crime report by committing the crime of interfering with electronic communications. The factual basis is on page, if I can read my handwriting, 58. Where it was asked, were there times where he tried to call the police? And he said he was calling the police, or you said you were going to call the police when he was assaulting you. She said yes. She was asked, and what would happen when you said you were going to call the police? He would take my phone. He would stop her. And she said specifically that he did this on May 25th, 2020, where he took her phone and smashed it. So I believe that's sufficient factual basis to bind over for count 8. Requested count 9, felonious assault.
What's the address for count 8?
Oh, I apologize. The same as Millstone, because that's the incident from 5/25/2020. Then for count 9, felonious assault. Same at the time, same Millstone address, 5/25/2020. PAC code 750.82. This is coming from pages 36 and 37, where the victim talked about how during this time he hit her in the jaw with a gun, with a handgun, which is a sufficient factual basis for felonious assault, which leads us then into the requested added count 10 of felony firearm. Date of offense again being 5/25/2020. PAC code 750.227B-A, where he used a handgun to commit that crime of felonious assault. The factual basis coming from, again, pages 36 and 37.
Right, that's still the Millstone address.
It is, Your Honor.
And what's the date again?
5/25/2020.
And is that's on count 10?
Yes.
So you've got 11/21/24. That would be the 5/25.
Yes, sorry. I knew there was another change I'd want to make to this.
Okay.
And I crossed it out. I just forgot to fix it. But that brings us to count 11, interfering electronic communications, again at the Millstone address, again on 5/25/2020, PAC code 750.5405A. Factual basis coming from page 58, where the defendant took her phone away to stop her from making a call. Sufficient factual basis for that count. Then we have aggravated stalking, requested added count 12, with a date range between November 16th, 2018 and the year 2024. And frankly, there is evidence to this throughout the entire testimony, but I would specifically point to pages 19 and 46, where the victim talked about the text messages that were admitted into evidence, the exhibits, where she was saying, "Leave me alone," and the defendant was saying, "The only way you get to leave me is in a body bag. You are my property, you belong to me." And then I believe it was page 46, where she talked about, yes, at various points during the relationship, there were PPOs and no contact orders in place, telling him he's not allowed to be in touch with him. And when asked, did that ever stop him, she said no. She made clear that there were court orders preventing him from talking with her, both PPOs, restraining orders, and unconditional orders. And yet he would continue to make unconsented, threatening contacts towards her.
Are you using the city of Lansing in that for that locale, or are you using?
City of, we can use the Millstone address, Your Honor.
Yeah,
A lot of those contacts happened while she was at her home.
All right.
And that is under the theory of either, for the aggravation theory, either doing it in violation of the restraining or court order, or credible threats against the victim. Because he had said over and over, "The only way you leave me is in a body bag." Then we go to the requested added count 13. Oh, I'm sorry. The count 12, I forgot to say the PAC code. It's 750.411I. I as an iceberg. So then we get to the requested added count 13, which is criminal sexual conduct in the first degree. This would have a date range of 2020, and the PAC code would be 750.520B1G as in George.
What's the anticipated location?
The anticipated location would simply be Ingham County. She may have clarified it, but frankly, I didn't write it down, and there are a lot of pages here, but it was certainly inside of Ingham County. But this was inserting the dildo into her anus while she was physically helpless and unconscious. The pages for this are pages 52 through 56, where she talks about how he gave her a drink, which almost immediately knocked her unconscious when she had never blacked out from that amount, so small amount of alcohol. She woke up in the shower with him, forcing her head under the shower water, not remembering anything, and then later finding a video of herself on his phone that matched up with that night, where she was unconscious and he was violating her anus with a dildo. And so we have a sufficient factual basis to bind over for requested count 13, CSC in the first degree. Then we go to requested count number 14, computers using to commit a crime, maximum imprisonment 4 to 10 years. The date range for this would be September 2023. The PAC code is 752.7973D as in dog. As the defendant committed the crime of personal identifying information, obtaining / possessing / transferring with intent to commit identity theft while using a computer to do so. In particular, Facebook, one of the exhibits that was admitted, which located both on pages 44 to 45 of part 1 of the transcript, and then also pages 17 and 19 of part 2 of the transcript with Detective Brandon's testimony, where the defendant had taken the victim's social security card without her permission, posted it on Facebook, blocking out the last 4 digits, and trying to sell it to people, saying that it was, quote, a good ID, unquote. This coupled with what was found on the defendant's phone, which was the defendant trying to find other social security cards and numbers to set, buy, and sell, and the infamous search term, how to commit fraud, lends pretty clearly to these two counts, where he was trying to, in order to commit identity theft, obtaining, possessing, and transferring her personal identifying information, her social security card. And he used a computer to do so. So I'm requesting bind over on count 14.
Is that the city of Lansing address or is that the Millstone address?
City of Lansing address. So requesting bind over count 14, computers using to commit a crime. And on count 15, personal identifying information, obtain / possess / transfer with intent to commit identity theft with a date of September 2023 inside Lansing. The PAC code being 445.67 as he intended to sell or transfer or attempted to sell or transfer personal identifying information of Alyssa Clark in order to commit identity theft. Then we have requested additional count 16, intentional dissemination of sexually explicit materials. This would be in the time frame of September 2023. PAC code 750.145E as an eagle. And the page number I'm getting that from is page number 50 of session 1, where the victim talked about and was shown in some of the exhibits that the defendant took sexual videos of her performing oral sex and posted them without her permission onto Reddit, and was even bragging about how many followers he has, so how she is blowing up and so many people are seeing this video of her. Again, taunting and demoralizing her. So I believe there's sufficient factual basis for that count as well. Then we have count 17, receiving and concealing stolen firearm. Date of offense 11/19/2024. PAC code 750.535B as in boy. For this, it is coming from page 15 of volume 2. And one moment, because I know that the address for the house that was searched is here. Uh, 3872 Wilson, Lansing, Ingham County. Detective Brandman testified about how when they executed the search warrant on his residence, they found multiple firearms, but one of them was reported stolen. That was the one that was actually hidden inside of his mattress. And so, as a result, people believe there's sufficient factual basis to bind over for count 17, receiving, concealing stolen firearm. Date of offense 11/19/2024. PAC code 750.535B as in boy, as defendant concealed stolen firearm. And then finally, requested added count 18, which is the felony firearm tacking on to the receiving, concealing stolen firearm. Date of offense is 11/19/2024. PAC code is 750.227B-A. The felony that was committed while in possession of a handgun is receiving, concealing of stolen firearm. And that is all the requested added counts, Your Honor. Frankly, in reviewing the transcript before today, there are still a litany of other felonies that this defendant has committed that, frankly, I could ask for, but I have put enough time and effort into Mr. Brooks. So I'm going to request that you bind over on these 18 counts.
All right, thank you. Mr. Freeman, response.
Yes, Your Honor, thank you. If I may, I would like to begin with the people's motion for bind over on, I think it's count 13. Yes, 13, the criminal sexual conduct first degree. Council referenced page 52 and 56. I would reference page 55. And the reason I'm objecting is because on direct examination, Mr. Pfeiffer was questioning our witness and talks about the alcohol consumption and so forth. And then she was asked, you mean he violated you while you were blacked out or unconscious? And her reply is, yeah, that's what's on the video. And more importantly, beginning on line 18 of page 55, volume 1, the question was, did you want him to do that to you? That was her opportunity to tell us her feelings about that, her perception of that. And she responded by saying, I mean, we do things sexually together all the time. Like we always have sex. But I was like, I didn't know about it. That was just part of, like, I was just trying to let you know that I think that those pictures were from that night. She doesn't express any sentiment whatsoever of being victimized. It's almost as if, well, you know, we have a couple of year history with each other and we, you know, have sex together and perhaps other things that may or may not be sexually related, but she didn't seem to object. She didn't seem to mind it. She was just being matter of fact and explaining that she saw it, and she was just bringing it to the law enforcement's attention to indicate that she was zeroing in on a particular day. And so I don't believe that that should be bound over. I'm not objecting to the idea that of what happened, but her perception was, you know, well, we do sexual things together all the time. So I object to that count being bound over to the circuit court. And if I'm going to make an objection, I always want the court to take me seriously. I appreciate and understand the rationale behind the remainder. That's the only objection I have is that one count, Judge. Thank you.
Thank you. Response, Mr. Pfeiffer.
Can't consent when you're unconscious.
All right. Well, the standard here is probable cause. And we have some added counts, so I'll go through each one to indicate. Count 1, which is from May 25th, 2020, at the offense location of 1701 Millstone in the city of Lansing County. There's a myriad of testimony, and those that we looked at the volumes. These were two volumes set from preliminary examination, but essentially, I'd say from 29 of choking and hitting, and then hitting in an area in which the defendant knew the complaining victim had a previous injury from punching, slapping, choking. There seems to be at a probable cause avenue, and I'll state each for the record. Location has been met at 1701 Millstone in the city of Lansing County for May 25th, 2020, and therefore location, offense, venue, and ID and a date, as Enrico Brooks was indicated, as the person who committed the offense. So count 1 is bound over on probable cause that the defendant did commit torture and intent to cause cruel or extreme physical or mental pain and suffering, inflict great bodily injury or severe mental pain or suffering upon Alyssa Clark, a person with his custody or physical control, contrary to MCL 750.750.85. I find probable cause to bind over on count 1. Count 2, which has the May 25th, 2020 date, specifically at the 1701 Millstone, city of Lansing, Ingham County address. In that defendant did assault in theory, but to the point of choking the complaining victim with hands on throat, both choking and was identified by Alyssa Clark as the person responsible for that matter. So count 2 has been met by probable cause evidence that the defendant did make an assault upon Alyssa Clark by strangulation or suffocation. Strangulation being the theory under count 2, with hands which choked around her throat. Contrary to the law of the state of Michigan, that is bound over on count 2. Count 3, once again, that she choked and was passed out and then hit following waking up. That I believe that that probable cause has been binds over that and so that is on in the year of 2020 at 1701 Millstone, City of Lansing, Ingham County is what I have on count 3. And so I find a probable cause to bind over on that offense. On count 4, under the theory of strangulation and GBH, that could be in the alternative. That happened at the Mill Pond address, 1701 Mill Pond in the city of Lansing, Ingham County, on date of June 2020, did make an assault upon Alyssa Clark with intent to do great bodily harm, less than the crime of murder. And that can be under the theory of strangulation or assault GBH pursuant to the testimony. So count 4 is bound over on probable cause. Count 5, which I have as the date of 2020. In the city of Lansing, Ingham County, that we have, that was the hitting of the rib cage, I believe. And so the hitting of the rib cage was testified to that it was not as specific as the others, but there was per in the city of Lansing on 2020, the hitting of the rib cage over and over. She testified, and I mean, comes from 2 sessions of the at least 1 session of Miss Clark's testimony, but that her bone was cracking and continued to crack through the existence of the punching. And then there was evidence of cracking through the skin. She testified to that. I would say in count 5 is bound over that occurred in the city of Lansing, Ingham County on the year of 2020 is what she indicated. Count 6 is a misdemeanor, I believe. A 1 year. And so that follows. And then we have count 7. Count 7 is the first time of the home address has been indicated concerning the home invasion that she was barged in on May 25th, 2020. That would be in the city of Lansing, Ingham County. She used an Eaton Rapids address. Eaton Rapids Road was the road address, but that's in the city of Lansing. And the defendant did assault her. She was present when the defendant was in the home and barged in, and so that meets the elements of 750.110A2. Corresponding testimony is page 29 for May 25th, 2020. There was also testimony at the Millstones address in count 8 concerning on May 25th, 2020 at Millstone, pursuant to 750.483A2B, that the defendant essentially took her phone away. I mean, that there's a fray going on, but there's interference with the electronic communication. I find probable cause evidence to bind over the Millstone address on count 8 for 750.483A2B. 9 is the Millstone address, so that's the Millstone address of 1701 Millstone in the city of Lansing, or is that the 575 Millstone address?
1701, Your Honor.
Okay. 1701 Millstone address that happened on May 25th, 2020, and that she was hit while the defendant was holding a firearm. She was hit with the firearm or the gun, doing the offense of touching of another with a gun in hand or firearm, this being used as a hammer or a blunt instrument device, and therefore felonious assault is bound over as per 750.82 for probable cause evidence that the defendant who was identified by the victim in concerning the felonious assault is bound over. The felony firearm is count 10 relates to count 9 in that the defendant was in possession of a handgun while committing the act of a felonious assault. So that's pursuant to 750.227B-A. That would be the same date at the 1701 Millstone, City of Lansing, Ingham County. Count 11 is the 117 Millstone, Ingham County, that occurred on May 25th, 2020, which essentially, as we indicated, was interfering with the electronic communications, which is the interfering with a telephone by grabbing the phone from the Millstone address at May 25th, 2020. That occurred. So I find probable cause evidence to bind over on that count. The aggravated stalking, which I see what counsel's saying. This occurs throughout the testimony of Ms. Clark, but we'll use the dates of 2018 to 2024 that Alyssa Clark was terrorized, frightened, intimidated, threatened, harassed, and that was in violation of what has been indicated was a restraining order or PPO against the defendant who she indicated, Mr. Pfeiffer.
Only for the date range, it has to specifically be November 16th at 2018 at the earliest due to statute of limitations.
All right, so November 16th, 2018 to 2024, we have that in the city of Lansing. No specific address because that occurred often. There is the Millstone address was mentioned in that on the pages, but I'm going to use the city of Lansing because I think this kind of developed over time. But we do have the Millstone address as a location. And I'll bind over on that aggravated stalking account. I think Mr. Freeman makes a fair argument that as to count 13, and we had a problem with count 12, but that's to count 13, which is pages 52 through 56. The victim was given the opportunity to indicate that they were not going to be involved in the CSC first. And there was the indication that she'd had something to drink, that she had blacked out, and that she noticed the photos had been used. And then as Mr. Freeman indicated, the question was asked, was this consensual or was this in the nature? And the victim indicated, all she had to say is no. That's all she has to say. And what she says is, I saw the photos, I recognized the photos, but we had sex all the time. And that is a problem. That is a problem for the court because it really was an easy answer to this, Mr. Pfeiffer.
Your Honor, what she said is, I mean, we do sexual things all the time, like we always have sex, but I was like, I didn't know about it. She couldn't consent to it because he did it while she was unconscious. And even if they have sex all the time, even if it's part of their regular sexual activity, dildos are used inside the anus. She physically and legally was incapable of consenting to this.
But she didn't say that.
She did. She said that she had no knowledge of this, that she blacked out. And the only reason that she knows that this exists is because she discovered video on his phone of him doing it to her. Even if she did this regularly as part of their sex, it doesn't matter because he did it while she was unconscious.
Yeah, see, I have you saying that. She said he inserted the vibrator into her anus while she was unconscious or blacked out.
Yes.
She said, I mean, we do things sexually all the time, like we always have sex. But I was like, I didn't know about it. That was just part of, like, I was just trying to let you know, I think those pictures were from that night.
Yes, on page 54 is when she starts talking about the video, which is how she discovered it.
Right.
The reason that she knows it's from the night that she blacked out is because that's where it lines up with the photos. She says she has no memory of it, and that is what's required. She can't consent legally.
Doug, I agree. She never said that.
She's not required to because she's unconscious.
Right, but she does have to recognize the video as being.
Which she says she does. She said that she found he had, like this toy, a vibrator, and he had inserted it anally into me. And to be clear, you were not conscious for that? And she says no.
She said that. She also said she normally does not black out on 2 shots, and she had 2 shots that night. So the inference is that she had more to drink or that there was something in the drink.
That is what the people take away from is that he had drugged her.
All right.
And then he did this to her while she was
So,
unconscious.
Mr. Freeman, you understand the fight. You understand the fight.
Yes, Your Honor, and I think we're going a little bit too far outside the lines if we start talking about drugging.
I agree. I agree.
cocktail. But to get back to the point, yes, as a matter of law, as a matter of fact, it cannot be disputed that if someone is totally unconscious or blacked out, or in other words, not conscious, of course, you cannot consent at the time. On the other hand, I think it is relevant that she was testifying from her experience of, I don't know, 2 years, 3 years, however long they were together. She has a couple of children, I think, by my client. And that this kind of thing is not necessarily all that unusual.
That is not what she testified to. At no point did she testify it was not unusual for him to violate her while she's unconscious, or even to use a dildo. She said they had sex all the time, which in a relationship is normal. She said this had never happened.
So I'll let Mr. Freeman finish his
Yes, Your
argument.
Honor,
and give you a
thank you very
response.
much. So my point is, I think it's relevant that what's her reaction after? What's her reaction after she discovers that this occurred? She didn't indicate that she felt violated or that she was a crime victim from watching that video of herself. And I think that that all goes to as to whether the crime was committed. It also has to do with the mens rea of my client. If he did that with the understanding and appreciation of that she would not object and that this would not be so terribly out of the ordinary, then that is a concern as to whether that constitutes a felony offense.
To be clear, the defense is now no crime was committed because the rape victim did not respond to being raped in the way the defense counsel thinks a rape victim should respond. That is not a defense. It's disgusting and offensive. And as far as any mens rea, that is an argue for the trier of fact, the jury, which demands that this be bound over.
Well, we're sitting at a probable cause level, and I will allow the probable cause to go to jury concerning this matter. I will bind over on a CSC first, although I have to say, I think this is a weak count at probable. And so we're binding over on probable cause to go to a trier of fact for doubt beyond a reasonable doubt that CSC did occur in the year of 2020 in the city of Lansing. That the victim does indicate in pages 53 and 54 that she was not aware of these images of a dildo entering her anus. That constitutes CSC first for physically helpless concerning what she said. So I will bind over on count 13 after further argument. But I do think that is a low-level bind over as to the probable cause based on the witness's testimony. So I'll bind over on count 13 as to the city of Lansing in the year 2020, into the city of Lansing into computers at location of city of Lansing. There was a lot of testimony concerning the use of a social security number and the use of and the transmission of various information. So I do find that 14 has been met at a probable cause level, that the city of Lansing, this occurred in the city of Lansing on September of 2023, pursuant to 752.7973D, that the defendant did obtain, possess, transfer with the intent to commit identity theft. He almost bragged about it, saying, here it is. Count 14 is met by probable cause level. Count 15 in that in the city of Lansing, the defendant did obtain, possess, transfer with intent to commit identity fraud on September 2023, pursuant to 445.67, the attempted seller transfer of Alyssa Clark. That may be the social security number in regards to, because we had a lot of testimony concerning the dissemination of different materials. One was at least a social security card and a card number. And then there was the dissemination in the city of Lansing of a photograph, which appeared to be the victim giving some type of oral pleasure to or oral stimulation to the defendant. And that would occur on September 2023 pursuant to 750.145E. I believe at a probable cause level, oral sex did occur and a photo was taken and disseminated as to September 2023 in the city of Lansing on that count. So I find probable cause evidence to bind over as to location, offense, venue, ID, and date pursuing number 16. And then for 17 all started from the second session of the February 7th section, and it was done by a search warrant that was done at 3872 Wilson in the city of Lansing, Ingham County. Pursuant to that search warrant, a firearm was found. This defendant is charged with receiving and concealing the firearm based on the testimony of the detective who did the search warrant, found the firearm in the materials of the defendant. I find there's probable cause based on the finding of the firearm in the possession or the materials of the defendant to bind over as to the receiving and concealing as can count 17, which would be that Wilson address as to November 19, 2024. And then the 18, felony 18 is the felony firearm that comes out of that November 19, 2024 occurrence, that the defendant was in possession of a firearm and it was committing the felony of receiving and concealing a firearm pursuant to 750.227B-A, and I will bind over on count 18. So the counts that are bound over in the matter, and I have the examination was held on 2 dates. It was held on December 19th, 2024. It was also held on February 7th, 2025. Find there probable cause to exist on the amended charges. 1 through 6 were discussed for bind over. And then there was an added 7 through 18, I believe. 7 through 18 that were requested as additional bind over that we will set the matter for. This is a bond is set at 100,000 cash surety on the first 6 charges. So I'm binding over after the bind over on this matter. I'm binding over on counts 1 through 6 that were original part of the file, and then 7 through 18 that have been added. And original bond was set at 100,000 cash surety. Anything else? So your time in district court is done, Mr. Brooks. You'll be on to circuit court where you'll get any type of notice to appear from your attorney, Mr. Freeman. Anything else before I sign the bind over documentation, Mr. Pfeiffer?
The people would like to respond.
All right. And then Mr. Freeman, you'll have a response to bond. Bond is set at 100,000 cash surety. You may proceed, Mr. Pfeiffer.
To be blunt, the people are requesting $250,000 cash surety. There is a litany of criminality that was testified to by the victim. And again, not even all of it resulted in charges here. She also talked about him threatening to shoot another woman. He has decided to commit crimes in almost every single category that he could, from torture to home invasions, effectively sexual bribery, extortion, identity fraud, identity theft, firearms crimes, stolen firearms, stopping her from calling the police, and stalking and rape. I believe $100,000 was appropriate for the initial 6 counts. We are at 18. I believe that $250,000 is appropriate given the defendant's actions. given the testimony and the, I mean, explicit evidence. These statements of, you cannot leave me. The only way out is a body bag. You are my property. You belong to me. Are chilling. I believe $250,000 cash surety is an appropriate reflection of this defendant's case and his charges.
Thank you, Mr. Freeman. And I'll say for the record, Mr. Freeman, your client has been remanded on since the 100,000 has been met, okay, since the initial arraignment.
Yes, Judge. And he's been in jail for what? If not fully, close to 4 months, and he hasn't been able to post 100,000. He's not going to be able to post the 250,000 either. So if it makes counsel feel better, that's fine. I'm not going to object. There is another matter before the court closes this record. The court, if I may, the court will recall that there was some discussions on the record early on in the case about my client either filing a grievance with the Attorney Grievance Commission.
That was during session 1. I saw someone, yeah. I remember
Okay.
that.
Both.
Okay.
And as a defense counsel, and I'm probably for prosecutors too, you try the case and you represent your client, but you're always in the back of your mind thinking about appellate issues. And so I have a document that I received from the Attorney Grievance Commission dated February 11th, 2025, that for all intents and purposes says that the request for investigation as to my behavior in this particular case was reviewed, and that there would be no investigation, and they closed the file. So with the court's permission, I'd like to just add this to the court file for appellate reasons or otherwise, 2 years from now, there's a motion for a new trial or something.
Without objection, Mr. Pfeiffer, we can put that, we can make a copy of that, so you have the original, if that's not a copy, and we can place it behind the transcripts.
I think that'd be appropriate, Your Honor.
Thank you. This is the original.
All right. So I'll have Megan make a copy of that. And we'll put it in the court file as dispositive, since we did at both sessions discuss that a grievance had been filed.
Yeah. Yeah.
All right. All right. With that understanding, I'm going to set bond at council's request at 250,000 cash surety.
Megan, can I get a copy as well?
It was $100,000 on the first 6 counts. Now we've added 7 through 19 with various counts have added, including at least 1 20-year and 1 life offense that were bound over in a myriad of felonies. So I'll raise the bond amount to 250,000 cash surety, and I will sign the document accordingly for today's date, and then I will place the copy of the Attorney Grievance Commission indication in behind the preliminary examination. Thank you. And we can go ahead and place that in the court file.
Thank you for understanding, Judge.
No worries. All right, so that's I'll set it for I will indicate that this is for today's date of March 28th. And that I placed the document behind the 2 transcript preliminary examination. I'm signing the bind over, and your next date will be in circuit court. You'll get it from Mr. Freeman. Okay, sir? All right. Anything else for the record in docket 2403427, Mr. Pfeiffer?
Not from the people, Your
Mr.
Honor.
Freeman.
No, Your Honor. Thank you.
All right. Thank you. You're all set. I will return the exhibits because they'll be in my file, and I'm afraid but we've got all the exhibits.
I'm with you.
All right.
Yeah. Thank you, Your Honor.
Thank you, Mr. Freeman, and thank you, Mr. Pfeiffer.
Yes,
Did
Judge.
you want session 3's transcript? Huh?
Maybe, I don't know.
Mr. Freeman,
Ma'am?
you want session 3 transcript?
Oh, no, not from today. No.
Are you sure?
Yes,
Okay.
thank you.
Again, we're good with count. We have the first 2 already transcribed, I think.
Yeah, that's the meat and potatoes.
Yeah, that's the meat and potatoes of it.
Okay, did you send me an addendum for me?
I think I did.
I'm gonna go try and catch John before he leaves, since I have to talk to him about the property.
All right.
Have a good weekend, guys.
You too, Mr. Pfeiffer.
I'm gonna get some much needed rest.
Sounds good. Have a good one.
All right, and my pen. So it's found over on 1 through 6 and added 7 through 19, and I went ahead and signed that. And then I just replaced it. I replaced the other addendum
All right,
on that one.
okay.
So,
So, attach and go over.
so there's that one.
Okay.
And that was. Let me make sure I've got one.
I'm wrong every time, so I don't want to do that.
Will we turn it in?
Yes, he's just coming into executive ID if you want to. So. I'm establishing the actual ID for the actual incident with the hearsay of 2017, which I'm going to get into Officer Turbo.
That's me.
Yeah, and then I'm going to match names, please.
Scripts go in the hot box too.
Yep, because
All right, let's go ahead and put 2500455, Mr. White.
Yes.
And this is Adonis Clemens.
Correct.
I was adding, we took a long time for that motion, but that was after, I think we started that in December, so. It took a little time.
Yeah. Are you on the record?
No, we're not on the record.
You got an uphill battle when council.
All right, so we're on the record in docket 2500455. That's people of the state of Michigan versus Adonis Clemens. Will the parties please introduce themselves for the record? Ms. Azell.
Gabrielle Azell, Assistant Prosecutor for the people.
Mr. White.
Jamie White here on behalf of Mr. Adonis, who is seated at the defense table.
And sir, you are Adonis Clemens, is that correct?
That's correct.
Thank you. This is the time set for preliminary examination. I believe we previously started this preliminary examination. We had Tyler, was it Mr. Perry?
Correct, John.
Mr. Perry testified, was cross-examined, and then it's my understanding that we asked for a continuation. I believe there was a funeral, and one of the officers was funeral. So Mrs. Zell, how are we proceeding today?
Your Honor, the people are ready to proceed today. We do have 2 officers that we would ask to take testimony from. The people also plan to proceed under Court Rule 7, under MCL 768.27C.
That's the hearsay rule.
It is, Your Honor, and we would be trying to establish the foundation for that under Officer Turbo's testimony.
All right. And then Mr. White, is that your understanding what we're doing today? And do you have any comment?
That is my understanding, Your Honor. My only comment would be, and I don't know if I said this on the record last couple of weeks ago or not, but when we were here a couple of weeks ago, it came to my attention there was an intention on the people's part to introduce evidence pursuant to MCL 768.27C. I indicated that I had not yet received notice, and it was further indicated that I would get it, I think that day is what I was told. I'm told it was sent to me today, but I've been in prelims all day, and we stand here, I've not received any notice showing the intention to do so or the substance of what's intended. And there was a couple of different reasons I wanted that information before today, and it is my understanding Mrs. L says she sent it today. I have no reason to disbelieve her, other than it's not in my email if I sit here today. And the court rules pretty clear that, it needs to be 15 days prior to the hearing, unless there's some overwhelming reason to not do so. Being this the second hearing, and it still did not occur in a timely fashion, I certainly want to make a record of that, and I would ask the court prevent any testimony from coming in pursuant to that statute. There is one other comment, Judge, and I'm not sure how the court wants to deal with this. Mrs. L and I have spoken about this to some degree. I was just notified, and she has no reason to notify me about what I'm about to say. Right. I'm not suggesting that it was deficient in notice, but I was just told that it's her intention to try to establish ID through a jail officer who is not named in the report. And I'm proffering evidence. I'll let her speak for herself, but my understanding is that what's going to be proffered to the court is that the jail officer is going to identify Mr. Adonis as the person who turned himself in with me at the time of an arrest that was significantly after this incident. So I'm having a real hard time seeing how a jail officer is going to use arguably meeting him during his turn-in and tying him to the incident. I'll stipulate that he has the same name as the individual who was allegedly at the residence, but I just don't see how they get there by way of ID at the time of the turn-in. Had he been arrested that day, I think that's a very different story. But I don't think you're going to hear any direct evidence of anybody actually identifying him as being there. And so this ID, again, not to be redundant, but the weeks and weeks after the incident, actually months after the incident, a jail officer can come in and say, this is the guy who was at the house. Unless there's some other tie-in that I'm missing. Again, I don't want to speak for Mrs. L, but
I don't have identification made in this case.
It's not.
Correct, Your Honor. That is something that we would be trying to do under the 27C hearsay. We would be establishing the correct foundation to do so, including the information that was given regarding the defendant or the suspect in these situations. Name, date of birth, description of him through Officer Turbo that was gathered on the date of the incident. With that, Your Honor, we would additionally support that identification with the confirmation of the name, date of birth, and description at time of turn-in.
All right. So is officer, so you're doing that, you're questioning that in regards to whether Officer Turbo can pick this individual out as the person who was there?
No, Your Honor. I believe the issue is that in this situation, Mr. White would ask that we do not ask the officer who actually did the booking, confirming Mr. Adonis's ID, taking him into custody, right, as Mr. Adonis being the person who's in the courtroom today. I understand that argument. Is Mr. Turbo, I guess some of this is going to be is whether Mr. Turbo can make identification. So, Your Honor,
if identification is made some other way.
Yes, what the plan is to do is to have Officer Turbo testify under the 27C to the description that the victim provided the officer of the name, date of birth, and.
But he didn't actually see.
He did not, Your Honor.
And 27C goes to hearsay. We're talking about a jail officer, so we're not even dealing with statements made by another person.
But this came up earlier today. As a matter of fact, it came up this morning on another Adam Pfeiffer case, and it's my understanding that someone just has to pick out that this person, Mr. Clemens, is the person who is Mr. Clemens in the courtroom today. And that's the same person. And then I can extrapolate that, or infer that the statements made pursuant to identification, that's all valid, but none of it's valid if Mr. White doesn't have notice. And that's the problem is that the jail officer is not on anything right now. And so that becomes a problem because I can have Mr. Turbo testify and Mr. Walter testify, but we don't have ID through either one of them. So then we're going to the jail keep. He has not written a report. So this would be Mr. White's first notice of that. I don't think he's on the.
He is not. His name is not on the police report, Your Honor. There is a supplemental report that I don't even have that was not shared with the defense. If the court would prefer, we can adjourn and I can get
But
that.
I think we've got a two issue here.
But the other issue, Your Honor, is that notice isn't required for 27C until trial.
Correct.
We are not at the trial stage.
This is
The
a preliminary-
confrontation clause doesn't apply
Right,
here.
right.
So that notice, I understand there's no notice for simply the officer that did the booking who is present here today. However, it's my understanding that Mr. White walked his client to that booking and was there and present for all of it. I don't have that supplemental report, and if what I heard is true, Mr. White would be in a better position than I am to challenge the testimony of the officer.
But at least there would be something out there that Mr. White would go over in order to cross-examine concerning identification of the officer. So I'll leave it the notice for trial is different than the notice for prelim on 768.27C. The confrontation issue is a big one at trial. It's not so much because the legislature's determined 768.27C is coming in a prelim. We don't consider prelim a trial. That's my understanding. I do think though that Mr. White can get notice on that if you intend to use it. That's kind of beside the point. The real identification, in order to make a bind over, I have to make ID, and ID can't be made through 768.27C except an inference that is the person. So we need somebody who actually knows Mr. Adonis, and that's why we're having this conversation, because we have somebody who he turned himself into and indicated my name, date of birth, etc. I do think Mr. White should have notice of that if that's the route we're taking. I think that's fair. I think because it's not in the police report and it's not in there's no mention of that as far as the witness list. So I would leave it to counsel. I will entertain an adjournment. Mr. Clemens is not here. You have law enforcement witnesses that can be called back. Okay. We don't have any non-law enforcement witnesses. Mr. Clemens is out. So I would entertain an adjournment in this matter based on the note. Now that we have notice and now we know the theory of the case for whatever witness who can make a report on it and give it to Mr. White so he can review it in order to be prepared for preliminary examination. I'll leave that to counsel to discuss. But Mr. White, that I'm more apt to do it for the lack of notice as to the witness than I'm doing it for the lack of notice for the domestic violence statement, because that's more of a circuit court issue than a preliminary examination issue.
Understood.
Yeah.
I certainly don't want to use time unnecessarily. And so I appreciate the court at least being open to an adjournment. Could I potentially just speak?
Absolutely. You can go outside and talk to your client, let him decide.
Okay. It's probably about 5 minutes.
Okay.
Thank you, Judge.
Put your
Or because of the nature, serious nature of the offense.
All right, so we're on the record in 25-00455. It's been brought to my attention, we're still in the middle of a prelim. Mr. Perry has testified. 2 officers were going to testify today, but we are going to have a third witness potentially testify that is not in the police report, that is not, that we don't have a report from. I think some notice has to be delivered in regards to that, no matter how small. And we've done this. We did this earlier today. We did the same thing earlier today. But I do think Mr. White should get notice and have the opportunity to prepare any type of cross-examination for a witness that he was not prepared to do. With that understanding, we will adjourn. Now, here's part of the problem. We're going to adjourn post April 21st.
You're getting your knee done.
Yeah, because I get my knee done next week. So we will adjourn. I find good cause. He waived his 21-day rule, so that's not an issue, and he's out, so that's not an issue. So we will adjourn at defense request. And defense is requesting because they don't have notification from prosecutor of a new witness. And so if you want to let the officers go, you can. They're probably, I don't know if they're here or on call, but you can tell them if they want to talk about it, just tell them it's being adjourned and I can give them the date. You can get the date. The date will be post April 21st of
How does May 1st in the afternoon work for Mr. White's trial schedule?
May 1st in the afternoon.
May 1st is fine.
All
Thank
right.
you for checking.
I'll say so.
Would
May
2 o'clock
1st.
work, Mr. White,
Pardon me?
2 o'clock?
2 o'clock would be fine. Thank you.
Excellent. All right. So we'll adjourn to May 1st at 2 o'clock for notice to be given. What is the name of the witness you intended? So we have notification purposes.
Yes, if I could just give me 1 second.
That's
My
fine.
cases got out of order. So. The name is Officer Adam Walter, and just to make the record clear, he was one of the 2 officers here and ready to testify.
All right. So Officer Adam Walter, if he wants to, he should develop a report of what he understands took place during the booking process and booking what he's going to testify to for Mr. White to review. Okay.
And I do believe that one was made on the day of the actual booking. I just do not have access to it. So I will get that report and I will have it sent over hopefully by Monday of next week.
All right. And yeah, we should have that delivered as part of discovery. All right. Anything else for the record? May 1st at 2 o'clock. Anything else for the record on 25-00455? Mrs. Zell.
Not for people.
Mr. White.
No, you're on.
All right. You're all set. Thank you for your appearance today.
Look at the surgery, Judge, if I don't see you between now.
Yeah, we'll see. Next Wednesday is the big date.
Are you gonna be able to this summer or?
Hopefully.
Yeah.
Hopefully.
Okay.
Hopefully I'll be better at it.
Yeah. Well, I'll show up this year.
Okay. All right. You let me know. I'm always there.
All right, take care.
You too. This is Mr. Brooks.
Guys, was this meant to be in this file?
Wait.
I think this is Enrico Brooks.
Okay, I thought that top one was this one.
No, this one,
I had a red one.
I gave you Clemens. I should.
Finally.
Megan, can I see that file?
Do you want that in the file?
I want, here we go. There we go.
Thank you.
I did not want that in the file is what my answer should
That's
have been
what we were
no.
looking for.
That's exactly what we knew shouldn't be in the file. All right, Mrs. Zell, you've had a full week.
I sure have.
You've had a full week.
Mrs. Valley,
So-
you've earned that working from home next week.
Hopefully I get to actually do that and I don't get called in to cover for anyone.
You know how you prevent that?
By telling everyone they need to stay.
You just put your phone someplace and you don't look at it.
I wish.
The one thing I can tell you is if they're asking you to do something, that's good news for you.
Yeah.
Because they don't ask people that don't get things done. So it's always good news to get, you always want to be asked to do things, because if they're not asking you to do things, they'll find a way to marginalize you.
We meet at the courtroom or get us off of Zoom or whatever we do at the end